Good morning, everyone. Thank you for being here. Thanks to our members of our commission as well as all of our guests. I am going to ask for our roll call. Now we're going to do it in a little bit different fashion. So we're going to start to my right, and I am going to ask each person to identify themselves so those in the room are clear and those watching are aware. I'm Harriet Myers, and I chair the Texas Access to Justice Commission. It is a great privilege to do so. Congratulations.
I'm Laura Livingston. I'm currently serving as the interim director of the commission.
Betty Fotis, I'm the executive director of the Texas Access to Justice Foundation.
Bob Horgan, I'm the chief of staff for Senator South. Alistair Dawson, and I serve on the commission.
Just the top to Liz Payne, and I'm a commissioner.
Brad Hoban, and I'm a commissioner.
Karen Miller, and I'm the executive director for Texas Legal Services Center. Kimberly Schmidt, communications officer for Texas Access to Justice Foundation.
Billy Tisdale, and I'm president of the state bar of Texas.
Trey Atfield, executive director, State Bar.
Chris Bitter, chief legal counsel for the state bar.
Terry Cottonham, commissioner. Roland Johnson, commissioner.
Judith Stephanie, and the lieutenant governor's appointment to the commissioner.
Dick Chew, I'm a commissioner.
Karen Nicholson, commissioner.
Martin Bell, commissioner.
Hi, I'm Logan Summers. I'm with the National Center for State Boards. It's a lot also.
Nancy Yell, commissioner.
Lisa Hobbs, Commissioner.
Kevin, commissioner.
Brett Busby, Justice of the Supreme Court and for today.
Thank you so much. And I would like to ask for consideration of the minutes of the October 30, 2023 meeting. Do I have a motion in connection with those? Motion, is there a second?
Second.
Any discussion? All those in favor say aye.
Aye.
Any opposed? Okay, we now turn, as we always do, to the general public comment period. And I would ask if there is anyone with us who would like to make a comment to the commission at this time. I would appreciate that you would only comment on something unrelated to what we will take up with respect to the working group report later on. There will be public comment on that and separate timing on the agenda. So is there anything other than that? Hearing none, then I'll pause and make sure I hear none. But this commission has a great burden, as we all know, a burden, a privilege, and an obligation to consider access to justice in our state and in cooperation with entities around the nation, actually. There is no person that I know of that has had greater impact on access to justice than our Chief Justice, as he served as chief of the chiefs, not once but twice. So I now have the privilege of turning the floor over to our Chief Justice, who needs an introduction.
Thank you, Harriet. The justice gap, the difference between the need for basic legal services and their availability is, as you all know, wide, deep, and long-standing. It's wide in Texas. There are 2.5 million households and qualify for legal aid. 820,000 get it. Nationwide, it's in the same ballpark, 5 to 10% of the need is satisfied. It's deep in that it includes veterans, victims of domestic violence, victims of trafficking, death parties, family parties, housing parties, all sorts of cases, in which people who need these basic civil legal services, can't get them, can't afford them. And it's long-standing. The Legal Services Corporation was, signed into law by President Nixon in 1975. This commission was created by the Supreme Court in 2001. It's been a project, of the justice system for at least 50 years, but it's going back, actually to the Johnson administration and years before that. So, it's, something that we've worked on a long time. It's also appalling. It's just, too much to think almost, that here we are in the 21st century, and in the United States of America, Texas, and people who need civil legal services can't get them. I know Chief Justice Polk on our court was a big supporter of access to justice. He helped support IOTA when it was coming into Texas, and the court has been committed to access to justice since the mid-80s. It's a priority of every state in the country, especially every state Supreme Court. And we've got resolutions that I know you've seen and worked with the Chief Justice's reports, calling for various different improvements in the availability of legal services. The profession has been a huge help. We've taken polls over the years of the number of pro bono hours contributed by Texas lawyers. Last poll I saw, it was around 2.5 million hours. That's approaching $500 million in free legal time. And the bar goes beyond that and makes contributions every year to the big statement and other ways to the for the support of access to justice. The state has helped. Basic Civil Legal Services has had a public appropriation since 2009, when Chairman Ogden of the Senate Finance Committee pushed for it as interest rates were going to zero and filed with this plummeted. The Jack Pope Act allows the Attorney General to divert settlements in cases that are brought by the state, usually consumer type cases, to the Supreme Court for use for basic civil legal service. We have special appropriations for veterans. The first one we got was 3 sessions ago. I asked Governor Patrick if he would support it, and he said absolutely yes. And when the budget came out, there was 0 in the budget for veterans. So I went back over and I said, I thought we were gonna work on this, and he said, oh, no, we are. But it'll be in the next budget. The next budget came out and there was 0. And then I went over on the final budget and I said, Governor, I thought we were gonna get some money for access to justice for veterans. And he said, Chief, you've been around this place long enough to know you don't get everything you asked for the first time. Good idea, you'll be back. We'll try it next time. I got over to my office and was feeling a little down, and my general counsel called about an hour later and said there'd just been some corrections made in the budget, and it's $3 million for legal aid for veterans, which I told Governor Patrick I would tell everybody from now on, and trying to fulfill that promise. And I tell people it's better to be lieutenant governor than chief, but I think everybody knows that. But support for domestic violence victims in Lansing, not programs that the state has helped support and fund, and it's been a bipartisan effort. It's not divisive, and the need is established, just trying to make the best use of the assets. But we have not met the need, and the matter is, we can't. It's just too big, but we must keep trying harder to close the gap. And that's why in 2020, the Chief Justice's passed a resolution urging members to consider what they call regulatory innovations. But what they meant by that was changes in lawyer professional rules that would allow non-lawyers more assistance in providing legal services. Lots of states, as you know from the report we're gonna talk about this morning, have already been trying that. I think the county is 9 so far. I know in meeting with the chiefs, during the year that number is steadily increasing. The object of everyone is to maintain high legal standards, make sure that the legal aid that's being provided is dependable and high quality, but also to enable lawyers to provide low-income people assistance more affordably. So, in October 22, Justice Busby wrote to the commission with the court's instruction to consider the use of paraprofessionals, which we talked about today, and also a pilot program that would allow a non-lawyer organization with an economic interest in the provision of legal services to sponsor a provider. In all of these things, we are blessed to be working on experiences and labor of other states around the country, but we also need to look at our own circumstances here in Texas. These are changes. Sometimes lawyers are uncomfortable with change, but the justice system must consider alternatives, given that the alternatives, given that the full funding for access to justice is not within reach. I realize there are legitimate issues, and that's why we need practical discussions, and not philosophically. That's why we asked the commission to look at this, because of the experience that you all bring to these issues. And in the field, you communicate with other lawyers who are on both sides of the bar in the field, and so we the court has a way of getting experience advice on these important issues. So it's not just a question, for example, well, whether NLO legal service providers is a bad idea, but how a pilot project gets experience that they do best work to be tried. So that's what we are planning on the commission to give us, is judgment, experience, recommendations, so that the board can begin to make more progress on closing the justice gap. We know that that the justice gap is real. It's not just an abstraction. Sometimes people they don't know exactly what you're talking about. But this group does and has the expertise to address it. It provides a forum for all views to air, and provides the Supreme Court with the best judgment, not just whether, but why not, and if so, how. The commission should be visionary and courageous. These are issues that challenge the very best beginners. The past has not provided a mechanism for solving the justice gap, crossing it, and so we must think ahead. We must fear the bad and worsening circumstances that the justice system is in. And I must say, I always must say, the human need is inestimable. It cannot be that Seaman First Class Chester Roby, a World War II veteran and longtime public servant, dies homeless because the clerk denied him the homestead exemption he was entitled to, when it takes Lone Star Legal Aid and Sandra Halton, his lawyer, a few hours to fix the problem. And Seaman Roby can rest comfortably knowing that the country he served came to his aid when he needed it. We appreciate the working group's thorough report. We know this is a developing process and it's never closed. So I'll just tell you that the Supreme Court always welcomes lawyer and public comment. You can send comments to the commission after today, and they'll forward it to us. You can send it to the Supreme Court clerk, to forward to the rules attorney. You can call me on my cell, probably won't remember it, but, the number you get better service, if you call the clerk. And finally, I just want to express my appreciation, and the appreciation of the Supreme Court to Kenneth, to Lisa, Judge Maxendale for their work and leadership, on this, for the last more than a year, and to all who have appeared at meetings and submitted comments to the commission for its consideration and recommendations that could lead to meaningful reform efforts to increase access to justice for low-income Texans. And special thanks to my colleague, Justice Brett Busby, for being the liaison to this mission and being dedicated to his work, and my good friend Harriet Myers, who chairs. So I look forward to the discussion this morning, and thank you for inviting me.
Thank you very much, Dr. Chad. And now I did want to ask, before we turn to the working group report, if there are commissioners on the Zoom, if you could, I know we have records of your presence, but it would be helpful if you would identify the presence.
I don't know who else is coming up, if you can hear me though, but this is Pablo Almaguer, Commissioner.
Hey, Pablo, I know the general is present. Apologize, we're having a bit of technical problem here, but
It may have just been his microphone because I don't see,
we're seeing Harry Reesner.
he's not speaking.
Anyone else? Thank you very much for that. So we do need everybody on code to speak up. I know I'm one of the worst to be heard, but if you could, when you're speaking, please speak up. That will be a big help to us. It's now my pleasure to introduce just briefly Lonnie Summers and Ray Kulak. They are earlier introduced to you as our representatives from the National Center for State Courts. We could not have done this project without the assistance of the center, and these two very instrumental individuals who helped us through this process. Lonnie and Grace both are senior court management consultants with the National Center. Very experienced. They have helped to guide us with a vast amount of experience in these issues, but also helped us when asked in any way we needed, and also provided to us national information about what programs are doing other locations and what their experiences have been. They helped us identify and bring to us special speakers to make sure that we have the education as commissioners that we needed for this project. So combined, they have over 30 years experience. They don't look like it, but they do. And so we are very appreciative to them, and I would appreciate your recognizing them. Now, I feel like the co-chairs don't need much introduction either. Everybody is quite familiar with these three individuals. They have remarkable backgrounds. So first, Justice Michael Nightingale is an arbitrator, mediator, and neutral, affiliated with the renowned Jams organization. He has served formally, of course, as an appellate justice in the First Court of Appeals in Houston. Before that role, Justice Nightingale served as trial partner at TAJC. And then, of course, has been appointed to this Texas Access to Justice Commission. The commission is grateful as we go through all of these. You can see by looking at there, it is a remarkable group of people who serve on the commission. Scratch myself in that comment, but I will say it is an amazing group of individuals that I don't know that I could say I've ever had a better opportunity to work with masters of our profession like we have on the commission. Hannah Lee is a partner at the law firm of Scott Douglas in Austin, of course. She recently was selected as the chair of the State Bar of Texas, a distinct honor from her colleagues. Her involvement dates back many years, and her service is vast in the State Bar of Texas, and we all know that. She has served in connection with the Supreme Court of Texas Task Force for Rules and Expedited Actions, the Austin Bar Association, the Austin Young Lawyers Association, the Austin Bar Foundation. She was the rules attorney for the Supreme Court of Texas, and a former law clerk with one of the Texas laws Jefferson of the Supreme Court. She's currently a member of the American Law Institute, participates on the Texas Supreme Court Advisory Committee, continues to be the Advocates Editorial Board, Supreme Court of Texas. We have pursuing task force, service course on this commission. Lisa Hobbs is a board certified civil appellate lawyer and founding member of the Team Hobbs LLC. Lisa was selected as the first ever general counsel of the Supreme Court of Texas. Before assuming the role of general counsel, her was court rules attorney. She is a member of the Texas Supreme Court Advisory Committee and the Texas Access to Justice Committee. Shifts and honors, but I'm sure she would prefer that we move on to the business before us. But just before that, I would like to mention April Faith Slacker, who is on the screen with us. We haven't had a chance to have April with us physically, but as you know, Laura is serving as an interim director of the commission. April is our now executive director serving remotely. So April, we welcome you and I thank you for being with us and look forward to when you are with us in person. So with that, we want to move to the work of the group that has been assigned the effort that has extended over now a year. And I know, Lisa, you're going to begin this presentation. We want to let them continue through their presentation, and then we will be taking comments from those that would like to comment. So, Lisa, I will turn the floor over to you.
Well, it's hard to follow two esteemed people like her, Chief Justice Nathan Heck, but I'm happy to be here today on behalf of the working group to present our hard work that has lasted for well over a year of this study. And I too want to thank the commissioners, all of you, for the support that you gave us in doing this study. You helped us so much along the way, and the least of which is agreeing to include the National Center for State Courts into the study. Because I know we've all given Lonnie and Grace a round of applause. But I know that I speak for Ken and Justice Massengale when I say we really couldn't be here without your expertise and your diving in deep to what other states are doing and guiding us along the way, whether it was, setting up things, like simple things, like setting up meetings, to big things, like helping us with feedback, from, people across the state. So, we really appreciate the commission's support of this study. I feel very supported, and I wanted to thank you. This started, of course, as Chief Justice Hack noted, with a referral letter from Justice Busby last fall. That referral letter, which is on page 15 of the report and recommendations, there's a link to it. But it has been our guiding post as we have engaged in the study. I can't tell you how many times you're like, well, let's get off the letter, see what it says. Justice Busby probably didn't think that we're going to do statutory interpretation of this letter, but you know, we're all learning here from you all. And then right after that, the commission helped us establish what truly is a blue ribbon working group committee. We got input from a lot of the commissioners, and certainly from the executive committee and Ms. Myers on our working group composition, which includes legal aid providers. You can see it on page 9 of the report, but we've got legal aid providers. We have academia, professors in ethics and other areas, judges on that committee, private practitioners, including private practitioners within the areas of some of our recommendations, family lawyers, probate lawyers, consumer lawyers. We had paralegals, because obviously we're studying paraprofessionals, so we included paralegals on ours, and many other legal professionals just that support the large legal branch that we have through the state bar and other means. And with that note of state bar, I do want to also thank the State Bar of Texas for their support of the study. We felt very supported along the way in every way, whether it was through communication or guidance or getting us in touch with stakeholders and all the things. So I do want to thank the State Bar as well for your support. So once we got the working group composed, we had our kickoff meeting in January of 2023. And this started off as a very informational working group because a lot of us didn't know, even though, as Chief Justice Hack said, this is being studied across the nation, and the Council of Chiefs had passed a resolution calling for regulatory innovations. We weren't exactly sure what we're getting into. So with the help of the National Center for State Courts, we had a kickoff meeting that was informational, that we shared with all the commissioners so that you would know the kind of kickoff of what other states are doing. I think Justice Act accurately reported that there are 9, it might be 10 states who now have a program, but there are actually 16 states who are studying this. So we're getting information from other states' study of this as well, not just those who've implemented it, but that input. And so that kickoff meeting was very informational with invited guests from all the states, as well as other experts in the access to justice world, to sort of get us motivated and informed to what's going on across the country in this regard. After that working group meeting, the kickoff meeting, we divided into 3 subcommittees that you've heard a lot about. We call ourselves KLMs. We might do some kind of get later. But we divided into 3 subcommittees. Kenan is the chair of subcommittee 1, who was looking at the scope of practice for paraprofessionals. We're going to allow paraprofessionals to have some limited license to practice some sort of limited law. What are we comfortable with as far as the scope of what we would allow them to do in a way that advances our ultimate goal of increasing access to justice, but still protects the public in making sure that they, just to have a limited license of some sort. I was the chair of the subcommittee 2. which is called the licensing subcommittee, and what I like to refer to as the nuts and bolts. If we're going to, provide a license to paraprofessionals, have a limited license, what is the scope of the regulation that we want, to have to, again, make sure that the public is protected through that program. And then, is it okay if I say that you drew the short straw on this? Yes. And subcommittee 3 is the group looking at non-lawyer, ownership, of firms, or economic interest in firms. And, I do want to, just to give you a little bit of, safety here. This is not something that it really was, he drew the short straw, like. So we're so glad that, I felt like it was a really good fit in hindsight, but it definitely was not something that you volunteered, towards. That really was, just, almost happenstance that Michael got to lead that fund subcommittee and gets to lead us in that discussion today, which I assume will be likely. Within these subcommittees, we brought in additional expertise. So we have a working group that you all helped us form, that includes a broad range of working group members and expertise across the state of Texas. But within each subcommittee, we added additional members to the subcommittee so that we would have even more expertise as we really dive into each of these 3 topics. The working group had, a total of 5 meetings, so the kickoff meeting and additional 4 meetings. So we were keeping the working group updated as each subcommittee was developing their recommendations. We were reporting regularly to the working group. We were also reporting regularly to you as well, the commissioners. And those meetings were public meetings. They're all available online. We allow public comment at those meetings. But they are recorded and posted online, which creates like an interim, like as we're studying this on the subcommittee level, how we're reporting to the working group. And I think among the subcommittees, I didn't actually count them, but I'm guessing we were over 20 subcommittee meetings between the 3 of us. So, so in addition to those, we had, we've been meeting a lot in 2023. That's a fair statement. And meanwhile, while we're meeting and studying these important issues and using the National Center to keep us informed about what other states are doing on a much more deep level than even we're presenting today. In the meantime, the National Center was helping us do stakeholder feedback. And that feedback is available in the report, and it came in a number of ways. We did online surveys with people who are interested in this world, whether in the access to justice world or just general practitioners. We did focus groups across the state as well to get more, so you don't just have to answer a question, but actually talk to us about what's going on in this world and how you feel about these proposals. We did direct outreach to both sections within the state bar that would be officially impacted by our recommendations, as well as individual practitioners, private practitioners, and legal aid providers. So we had a lot of direct outreach. In addition, we had an email address that we allowed public comment on at any time. And thanks again to the state bar. This feedback was given to us almost in real time. We got summaries. I promise you that except for maybe in the last 24 hours, Kenan and Justice Massengill and I have read every comment that we got through that. We were doing CLEs across the state, talking about our work, encouraging public feedback from our work through that email address. And so we took very seriously the comments that we got through that email, and we all read them, and oftentimes would follow up directly with anybody who gave us feedback that we felt like there's a conversation to be had there. One of the 3 of us would go through and directly call the person who had emailed to the extent we have their means to connect with them. And so, with all the stakeholder feedback, all the subcommittee meetings, all the information that we have from what other states were doing. And we'll get into more detail in that as we go through our subcommittee reports separately. On November 2nd, we had our final working group meeting. That was, basically an all-day meeting like this, 10 to 3. Where we discussed the subcommittee's, final recommendations and took votes on that. And that after that meeting, we actually did an additional survey of the working group members. So that we could ensure that our final report and recommendations accurately reflected all of that process that I just explained, from what other states are doing to the feedback that we received from those on the ground, to our subcommittee reports, and so we hope that, I know that it was a voluminous report that we circulated about 10 days ago. I think we gave about 10 days notice so that you would all have time to read it and digest it, because it is a pretty dense report. But we are thrilled with that, and again, to thank the National Center for State Courts for their help on that final report. We definitely could not have put that work product without your help, so thank you so much. And so that's where we are on the process. And now each of us are going to spend some time going through our specific subcommittee reports. And we are going to start with subcommittee 1, which is Kenan's group, to talk to us about the recommendations for the scope of practice for the subcommittee.
Thank you. Thanks everybody for being here today and sitting through this explanation of the process. The substance of being allowed to have the involvement. So as Lisa mentioned, I chaired the subcommittee focused on scope of practice issues. Paul Burr was the vice chair. And I think it's really important for me to say at the outset that as chair, I didn't vote. I listened to the extent that I drafted it was in an effort to capture majority perspective of the subcommittee. And it's really important for me to say that none of this would be possible without the subcommittee members who worked so hard, not only during the meetings, but also between meetings. And I'll address that in greater detail in a few moments, but I just wanted to say very clearly now that the credit and acknowledgement here belongs to those subcommittee members who dedicated so much time and energy and effort to this process. And my goal today is simply to report accurately and thoroughly, without getting into the weeds too much, the process and substantive recommendations that came out of this project. And although I'm here speaking, I welcome people from the subcommittee who are here with us today in working group to chime in if I accidentally misstate something, or if I leave a gap there that you think really needs to be filled at the forefront, because that's certainly not the goal. I'm going to be thorough and accurate in this overview. So another thing that I want to do before I dive in is express some additional gratitude to all the members of the bar who took the time to comment already, all people who are here today. I know you're all busy and have jobs, but you made time to be here today. To Justice Busby for not only guiding this project with the letter he sent, but also dedicating many hours of his time to meetings, to discussion between meetings, etc. It truly was a generous dedication of time and energy and effort. And of course, Chief Justice Kite for being a leader on access to justice just generally, and also in regard to this project. To Harriet Myers for again dedicating countless hours to all the meetings and guiding us and being just incredibly thoughtful at every step of the way in terms of what we did and how we went about doing it. To Judge Livingston, who got away from this building and shortly thereafter got snatched up to be interim executive director and of the commission, and has been very involved at every step of the way, including serving as a working group member and sitting on the subcommittees as well. And it's already been mentioned that Chris Ritter played a big role here, but I know that was a lot of effort to track the inbox that was monitored and to give us all of the feedback and to just be so on top of it meant a lot. Okay, so I'm gonna start by just going over the process, that the subcommittee went through primarily, and we'll get to the working group as well, but I think we have to start with the subcommittee because so much of the legwork was done at the subcommittee level. So first and foremost, I want to go through the letter, that's been referenced a few times because it really did, shape the course of the project, and, I know that it's referenced in the report, that isn't there as an exhibit, and so I'll just put it up. For all you, can you see it there on the screen now? Okay, so this is the October 2022 letter from the court, specifically, Justice Busby to Chair Myers of this commission, directing the work that we did. And what I've done here on the screen is highlight the components that really come into play with the scope of practice subcommittee, so that you all can see what we were grounded in, instead of us just kind of referencing it and you trying to remember it. Okay, so here we see from the court a directive that we need as a commission to examine existing rules and propose modifications in the following areas. This first bullet point is modifications that allow qualified non-attorney paraprofessionals to provide limited legal services directly to low-income Texans. So there's some concepts to unpack there. First, the concept of limited legal services being provided. I'm sure you all know that in the governing Texas ethics rules for attorneys, specifically in Texas Disciplinary Rule of Professional Conduct 1.02b, there's an express authorization for us as lawyers to limit the scope of the legal services we provide with the consent of the client. So this is a concept that's been in our ethics rules as attorneys for a long time. I think it's probably something we've all engaged in as attorneys. Sometimes it's, I'm just gonna help you with this trial but not the appeal. Sometimes it's, I'm just gonna help you with this letter, this demand letter, but that's it for now. But that concept is not novel, but I think it's important to point it out because it carries over into the recommendations that we're going to talk about later today. Of course, we don't have a rule for paraprofessionals about limited scope of practice, but that's something that's on the table that Lisa's going to talk about with the nuts and bolts component of our presentation. So turning back to the letter, it specifically says that this is about providing limited legal services directly to low-income Texans. So another thing that we had to do as a group is define what low-income Texans means in this context. And one of the things I can appreciate in sitting with experts in this space is that there isn't one set definition for low-income Texan, right? It can vary pretty significantly, and we'll talk about that in greater detail. And I'll go over with you and show you the proposed definition that we came to for low-income Texans in this context. Going back to the letter, again, though, I want to point out that the court gave us a non-exhaustive list of things to consider. We are engaged in this analysis, and I've highlighted the things that the scope of practice subcommittee, in other words, the subcommittee I was fortunate to chair, focused on. And specifically, we focus on what practice areas would we allow or recommend allowing these paraprofessionals to engage in limited legal services. Talked about eligibility criteria for the clients of these licensed paraprofessionals and whether the compensation to the paraprofessionals should be limited to certain sources such as government and nonprofit funds or not. So I'll stop sharing now, but I just wanted to give you all that context and kind of understand. Luis was saying you kept going back to the letter. We would go back to that language and thinking about what we needed to do and how we need to go about defining concepts. So Lisa mentioned that we formed these 3 subcommittees, as she mentioned that I chaired this scope of practice subcommittee, and I've told you that the scope of practice subcommittee did the work. And I think it's important for me to put up for you all as well, the members of the scope of practice subcommittee, because truly they're the ones who deserve the credit. So I'll go ahead and do that now. Can you all see that on the screen? So those are the members. I'll point out that some of these members are, of course, on the commission. And they got to be in the meetings and the working, some of them the working group, some of them the subcommittee, and also for this commission. We have Judge Nick Chu, who served on the scope of practice subcommittee until he was fortunate enough to come into a new position, as a probate, court judge. And so he was with us, and then when he left, we had another, JP come in, Sylvia Holmes. We have Karen Miller, who's been mentioned previously, Texas Legal Services Center Executive Director, who was on the subcommittee. We have Terry Tottenham, who of course has been involved with access to justice efforts for a long time, particularly in regard to veterans. And then in the room with us, here we have Jonathan Bates, who is a family law practitioner and expert, and he was instrumental in helping craft the proposals relating to family law matters, and also just across the board. So he deserves a lot of recognition, appreciation. We also have Ann Chandler here with us. She was with Houston Volunteer Legal for several years and now has her organization. And again, correct me if I get it wrong, Texas Immigration Law Council. Okay, so those are the people we have with us here today. Did I miss anybody? But you can see that the list is quite long. We had 27 members. We had diversity of backgrounds and expertise. We also, I think, with the subcommittee achieved a degree of geographic diversity that we didn't have necessarily as much on a working group. And so those are the people who did the work. And the other thing that I think it's important to mention is that when we engaged in our analysis, people weren't all on the same page. I mean, there were lots of times where we had disagreements, but I really want to commend everybody who served because people weren't disagreeable, even when they weren't on the same page. There was a high degree of professionalism and collaboration to where we are today. So now I'm gonna go back to the process a little bit more detail to walk you through what we did to get where we are. So as a full subcommittee, we met a total of 8 times via Zoom, each time for about an hour and a half. And in the report on pages 29 through 30, if you want to see a high level overview of what we did at those meetings, you can see that. We also have recordings of all the meetings, we have minutes, we have agendas, we have materials. And so if you want to be flooded with paper, just call me and I'm happy to help. But I think going back to the letter, you'll remember that one of the tasks for us was to identify the practice areas where these paraprofessionals would be able to engage in direct legal service, the provision of direct legal services. So we had to very early on think about what are these practice areas going to be and how are we going to go about coming up with proposals for them. So our process for identifying the practice areas was to strive to identify those areas in which low-income Texans are truly not receiving sufficient access to justice. And that's harder than it sounds because we don't have like this great collection of data that tells us exactly what we need to know about every case and every party. But we have several indicators that we use to try to identify the areas of greatest need for low-income Texans. Those included stats from the Office of Court Administration, which each year analyzes the number of self-represented litigants who file cases. And so that's a marker. It's not definitive, right? Because sometimes people choose to represent themselves, but many times they don't make that choice. They just can't afford a lawyer. And so they represent themselves. So that's a marker. We also worked with the Texas Legal Services Center, specifically in looking at the Texas Law Health website to identify areas where people are asking a lot of questions, the high traffic areas. So they have some great data from that particular website that we looked at in identifying high areas of need. We also, as Lisa mentioned, a lot of processes to get stakeholder feedback, both from the people who are serving as working group members and subcommittee members, and also from the commission, but also more broadly with surveys and focus groups and outreach to try to figure out where is the greatest need, where do we need to address our attention. And then we have national data, which of course is the same as Texas is unique, but it gives us an indicator of high areas of need, so we need to come in and do more than we have before. So after looking at all of that information, we identified 4 main areas to focus on. It was family law, probate and estate law, housing or eviction, and consumer debt. And then as a subcommittee, we decided to divide and conquer again into subgroups. And so we had a subgroup that was focused on family law, one focused on consumer debt, one focused on eviction. and one focused on probate and estate law. And there were several subgroup leaders, that I'll highlight in just a minute, but I want to tell you that in addition to the 8 meetings that we had as a subcommittee, these subgroups met between meetings and exchanged drafts and worked hard. And so I would, like I said, you're remiss not to recognize these leaders. I've already noted, Jonathan Bates. He was the one who was leading the family law subgroup and did a tremendous amount of work. And we had Craig Hopper and Judge Polly Spencer, who really took the lead with the probate and estate law, John Grieger and Paige Floyd, who took the lead with consumer debt, and then Professor Mary Spector and Sandy Garcia Boyd, I think, were the ones taking the lead with the eviction issue, though all of us worked together and chimed in along the way. Now, in addition to those subgroups, we have from Alaska something called the Community Justice Worker Model, where those individuals are supervised by legal aid attorneys and go out into the community to provide limited scope legal services to people there in Alaska. So that's a model that we as a subcommittee looked at. We had on the subcommittee somebody named Professor Sean Slack, who leads the paralegal program at Austin Community College, and he took the lead in doing a deeper dive into the community justice worker model and figuring out whether that might be something we could benefit from here in Texas. He reached out to nonprofits in Texas to figure out whether this is something that might help them, and he reported back to us on what he learned. We also had on our subcommittee somebody who's a former commissioner, Katie Fillmore, who assisted with doing some legal research and kind of thinking about what are the statutes out there that limit the practice of law that we need to be mindful of. What are some rules out there that already address some concepts that might come into play here? She wrote a memo that's been included in the materials. She also helped with looking at, as did I, from the authority of the Supreme Court of Texas to essentially issue licenses to paraprofessionals to engage in the limited scope of practice of law. And on page 7 of the report, there's a very high level overview of Supreme Court authority to license members of the bar to provide legal services. So essentially what we did is the subgroups came to our subcommittee meetings with proposals that weren't really in rule form, but they were kind of more, bullet point recommendations. And then we would take, like Lisa said, those recommendations, bring them up to the working group. And with approval, we ultimately put pen to paper and drafting proposed rules. And again, that's where I kind of came a little bit more, but the goal was to capture the majority perspective. And we met 2 times as a subcommittee and talked through the proposed rules, and ultimately had a vote that was via an online survey about those proposed rules. I mentioned that we didn't always have the exact same opinions about all the things, and that played out in the ultimate vote of these proposed rules. At the subcommittee level, we had 2 members who voted against them. The rest who participated in the vote voted for them. We brought them up to the working group, and the working group with some clarifications and we provisions unanimously supported the proposed rules that came out of our process. So I think that it makes sense now for me to turn to the proposed rules, and I know this report's been out for about 10 days, and I know you all can read and probably have already read these proposed rules, so I'm not going to spend time going through every single detail, but I wanted to give you an overview. So I know this is kind of dense, this material, you have a lot to read, and it might be helpful to sort of give you that context. So that's what I will do now. Everybody see all right? Okay, so I'm gonna walk through some things that just give you context for the general layout of these rules, and also point out a few things that may not be readily apparent to you from just reading through the proposal, and also highlight the definition that has some implications, broader implications of the project. That's specifically the definition of dwelling Texans. So broadly speaking, these proposed rules kind of have 2 different components, if you will. There's a new proposed rule for paraprofessionals on scope of practice, and there isn't yet a proposed home for this rule. It might be in the state bar rules, it might be JDCC, we don't know, but, so this is something for the court to decide where it would go. That's why you see it as kind of standalone text right now. But as separate and apart from that, we have proposed amendments to existing, Texas rules and civil procedure. Those start on page 4 here of Appendix A. And that's why they're red lines. So these are existing rules on the books, and these red lines are the proposed changes. So going to the new rule, just to kind of give you the context here, and again, this is Appendix A, starting on page 1, where you can see the proposal. The paragraph A of the proposed new rule lays out kind of the general parameters, if you will. And it states that the paraprofessionals licensed by the Supreme Court of Texas may perform limited legal services as set forth in the rule for Texas residents with low income. So you can see how this kind of ties right back into a referral letter for that. And then you have a definition of low income Texans for purposes of this rule. It means out or below 200% of the federal poverty guidelines is determined by the United States Department of Health and Human Services. The rule goes on to make clear that there's not going to be means testing, but rather you have the opportunity for people who are Texas residents to self-certify either a sworn affidavit or an unsworn declaration compliant with the statutory provision governing those that they meet this standard. So this is an area where there's a lot of debate, just so you know. People didn't have the same views across the board about how low income should be defined. And you can see some of this spelled out in the report, starting on page 31. There's a direct reference to these diverse views that we heard and talked through. There is also, I think, an important component here. This oftentimes we think about 200%, which seems big, and that is to break this down into dollars. And so in the report, you'll see charts that give you not just the percentages, but also what that means in terms of annual income for families of 1 to 4 and more. And so you can see on page 33 of the report, for example, that 200% mark really means an annual income of about $29,160 for a family of 1 and $60,000 for a family of 2. And that 200% mark aligns generally with what a lot of the legal aid entities and nonprofits are governed by when deciding whether they can help people. So for example, that by the way, is has a big range, right? Like LSC is 125%. I've learned along the way that the legal aid entities, they get the grant funding and there's different percentages tied to the grant funding. But 200% is an average that seems to be applicable for a lot of the entities. And that's something that I think drove the decision to choose 200% because we're going to have situations where if this comes to pass, there are paraprofessionals who say, I can't help you anymore. Let me refer you to legal aid. Well, legal aid can help them because they have the 200%. Like you meet our criteria. So there's a thought process that these individuals can move more readily between providers if that percentage point is more or less the same. But some other people felt it was too much. Some people thought this is not enough. We have, individuals, like if you think about $60,000 for a family of 4, that's not very much, especially in places like Austin. So there were others who thought it should be higher. There were 2 people who said you shouldn't have this at all. There should be no limit. You should just be able to make these legal services available across the board. But of course, we go back to the referral letter that says we're going to have these direct legal services specifically to low income Texans. So the majority vote was for that 200% mark. Going to the rule again and going over the practice areas, we have subpart B here addressing family law matters, subpart C addressing family law matters, subpart D addressing estate planning and probate law, and E addressing consumer debt law. So for each of these categories, it's about what can a paraprofessional who's licensed in family law do? What can a paraprofessional who's licensed in consumer debt do? What can a paraprofessional who's licensed in the state and probate do? So all of them have to have a particular subject matter license in order to engage in a limited scope services that are set forth in the rule. For each of these areas of law laid out in the proposed rule, you'll see that there are things that can be done in uncontested cases, specifically, and for example, in the family law context, The only thing the paraprofessional can do is going to be an uncontested case. So what we had to do in this rule is define what that means. And so you'll see in subpart F1 of the proposed rule, definition of uncontested, and then a definition of contested. So this definition applies to all the different provisions that we've talked about for the various areas of law. And it's just, I think, good to keep it in mind when you're thinking about the limits that apply to these paraprofessionals as envisioned by this rule. Another thing that you'll see is that in these proposals, there are some things that paraprofessionals can do with attorney supervision and some things they can do without attorney supervision. So we also thought it was important to spell out what we mean by attorney supervision. Because of course I can very dramatically mean it up from our own practices in terms of how we supervise. The other thing I'll point out is that in paragraph G here of the rule, there's a requirement that these paraprofessionals engaging in limited scope legal services have a written engagement agreement with their clients. And that the clients consent to this limited scope representation. I think any of us who have engaged in limited scope representation know that sometimes if somebody sees you as a lawyer, they think, you should do everything for me, you're my lawyer. See, it's important for them to understand that you're there only for a limited purpose. And that's what this particular provision is designed to do. We had a lot of conversation about what happens if you have a client and all of a sudden the case develops in a way that's extended beyond the scope of your license. And so that's what paragraph H addresses. And so this can play out different ways, I think, depending on the various practice areas. By way of example, as mentioned in family law, the only types of cases these paraprofessionals would be authorized to help with if they're uncontested. So if a case becomes contested, that paraprofessional has to step out. And so this provision addresses the procedure for getting out of the case with the guiding star being that you're going to do what you can as you're withdrawing to essentially protect the client's interests. And that's similar to what we as attorneys have to do right when we withdraw from cases. In paragraph I here, there's recognition of existing statutory framework about limitations on the practice of law. So we felt it was important to spell that out in the rule. And, you know, statutes can change. And so here it says except as permitted under Texas law, recognizing that we may see statutory amendments to these provisions over the course of time. Finally, there was some discussion about what people might think if you're spelling out what a paraprofessional can do with attorney supervision in this rule. What does that do to our existing practice, right? Or we as lawyers have paraprofessionals helping us, and that's permitted under the ethics rules in many ways with supervision. And so this particular subpart J spells out that nothing in the rule is meant to limit or otherwise reduce any path that any paraprofessional can perform with attorney supervision. And then there's some additional content there. Moving on to the proposed amendments to the justice court rules, and let me back up a little bit and give some more context to that. So the Texas Rules of Civil Procedure in the 500 series, that's where you see the rules governing justice court cases. The only proposed amendments that we have here are two rules governing justice court cases. There, you may have realized, is not in the proposed new rule a particular subpart that addresses evictions, even though we identify that as an area of high need. The reason for that is because in Texas, we have an existing statutory provision and rule that already allows people who are not lawyers to represent individuals in eviction cases. That's Rule 500.4 of the Texas Rules of Civil Procedure. So already a paraprofessional, that's not the word used in the rule, but it's somebody who's not a lawyer, can represent individuals on both sides of the V in eviction cases. Already in our justice court rules, we have a provision as well that allows for assistant, which is not defined, but it's not representation. It's something different from that, but that's in existing Texas Rules of Civil Procedure 500.4C. It's up on the screen redlined, and I'll walk through that in a minute, but as it stands, it already allows for assistance in court by a family member or other individual who's not being compensated. So that's already there. We had a lot of conversation about whether we need to do more, but we realize we don't need a brand new rule, proposed for scope of practice because we already have existing rules that allow representation by individuals who are not lawyers. So breaking the proposed amendments down a little bit in Texas Rule Civil Procedure 500.4, you see in A to C, the reference to the licensed care professionals. And this eventually just authorized, because we already have this general provision for authorized agents in eviction cases, but there may be licensed care professionals, for example, in consumer debt cases, who could come in and represent individuals within the scope of their license. So that's what we see there as proposed 500.4 A to C. And then in D, we see the community justice worker concept. So the idea of the community justice workers as proposed is that they would be trained in particular to do particular tasks under the supervision of an attorney who works for either legal aid or not another nonprofit entity. And so the training would be more discreet. The qualifications wouldn't necessarily need to be as extensive, right? Because they're providing limited scope, real limited, and with supervision. And the idea is that there are some areas of high need that don't require the same robust training, that these people could come in and help with those areas. There is, I think it's a footnote in the report saying that it might be good for the court to consider going beyond justice court cases. But for now, all that's proposed here is for community justice workers to be there in the justice court context. Finally, in the proposed amendments to 500.4 C, it's essentially just reducing the burden, if you will, for having assistance in the justice court cases. Right now, the rule says that the court may, for good cause, allow this assistance. Now, as proposed, the rule would say the court must allow that assistance absent good cause. So you still have discretion with the court, but it's just reducing that burden so you don't have to show good cause at the forefront. You just give the judge discretion to say, you're not helping, goodbye. If that's an observation that's made along the way, and I think that is one that's been made along the way by some JPs in our state based on the feedback we received. There's also a new proposed statement here in this rule that anytime you have a self-represented litigant who's being assisted by somebody, they need to be present for the proceeding where that assistance is provided. Because again, this isn't representation where you get to stand up and speak for me, this is assistance. And there's a concern that maybe sometimes the person assisting isn't necessarily speaking for the person who is being assisted. So this is a safeguard to ensure that the assisted person is truly having his or their interests represented. Finally, in proposed amendments to Rule 500.4, this is the rule about citations and eviction cases. And what's being proposed here is that you would go a little bit beyond what we do now by rule to let people know that they can get information on texaslawhelp.org. This is not a novel concept. The Supreme Court of Texas has in the not too past issued modified rules that direct people to texaslawhelp.org with the understanding that having that resource there is much better than nothing, right, for these individuals who don't know, never been in a court proceeding, and may not have lawyers. And then there's also an express recognition and then communication that individuals can represent themselves or be represented by an attorney or other individual. And then it points them to the specific rule spelling out self-representation and representation by others, including people who are not lawyers. So the thing that's not in these proposals is where we came down on compensation sources. Remember that in the letter that came from the court, there was also a statement that we need to consider whether the compensation sources would be limited or not. So that's not spelled out in the rule that we did as a subcommittee, provide feedback, not me because I didn't vote, but in that survey that I mentioned, the subcommittee members chimed in to address whether the compensation sources for these contemplated paraprofessionals should be limited or not. This was a narrow vote in favor of not limiting the compensation sources. So what does that mean? That means that instead of being restricted, for example, to government funds, you might have a situation where a client can pay a little bit of money, maybe on a sliding fee scale, for the services that are provided. That too is not a novel concept. By way of example, I know in the incubator program, there are several individuals in Texas who are lawyers who are providing services on a sliding fee scale, kind of based on what somebody can pay. So that again was a narrow vote, but that was the outcome. The working group itself, I don't think voted on the compensation, so as I was going through this, information, I realized that there wasn't a vote there, but we did report to the working group on the outcome of that vote at the subcommittee level, and there was no opposition, stated at the working group level. So that completes, my overview of the process and substance, except for I want to pause and ask for the members of the subcommittee and working group who were a big part of this process to correct anything I said that seemed wrong to you, fill any gaps that I inadvertently left. Okay, well, thank you very much for your time.
Okay, so I'm next. I'm gonna talk about the subcommittee 2 recommendation, and can I wait, since you have that up?
Yes.
Go to page 35 of your report.
Yeah.
And that is my subcommittee members,
Let's stop filming while I, scroll through and I can find people.
and so again, as I said, and then I'm gonna also ask you to pull up that final, appendix A. And so, my subcommittee, as I mentioned, is sort of the nuts and bolts for licensing subcommittee. So within my, subcommittee, we had as a right starting point, the regulation of lawyers, right? And so I tried to, pull into my subcommittee those individuals who have experience in Texas regulating lawyers as a means to help me understand how, or help the subcommittee understand how we would want to regulate paraprofessionals as well. So you'll see from this list that we have individuals who are heavily involved with the state bar disciplinary process. We have the head of the Board of Law Examiners, who is the entry level for regulation of lawyers. We have the head of the legal certification board. I'm probably getting that name wrong, but TPLS. So they have experience giving exams in specific subject matter areas, which is something that we're going to talk about. We had a professor at one of the who's head of the paraprofessional program. It's a paralegal program in legal studies at Texas State. So we have academia here, we have providers, we have judges, including Judge Sid Harrell, who is the chair of the judicial certification. Judicial branch certification. This is a running joke with us that I can never remember whether it's JBCC or JCBB, but it is BCC. And so Judge Harrell heads that up, and that is an entity that regulates a lot of individuals, non-lawyer individuals that touched on in the judicial branch. So everything from court reporters to processors, guardians. So we have regulatory experience within the judicial branch of non-lawyer individuals and professionals. And so Judge Harrell was a great help on that. And then Ellen Lockwood is a paralegal, a very experienced paralegal, very involved in the State Bar of Texas paralegal section, and also is the person who wrote the ethics handbook for paralegals. So we had a great deal. It's a small committee, and we got along very well. We had no votes that were actually, but it was a small committee with a large amount of experience in this area. And so I think all of my subcommittee members, we met over 7 times, and as Ken said, there's so much that goes on behind the scenes between each subcommittee member. And so then Ken, if you'll go to appendix A. Thank you. I could not afford Ken's hourly rate, so I appreciate it. Here being my paraprofessional. Generally, I want to talk about our general philosophy from that we started off talking about as a subcommittee, that I think the working group adopted, and that comes from lessons learned from other states who have licensed paraprofessionals. And that is that we wanted what I'm gonna call limited regulation of paraprofessionals. We saw overbroad regulation from other states that might have defeated the program, including in Washington. So we aimed for some kind of limited regulation commensurate with the limited legal services that the license would allow a paraprofessional to conduct as was being studied by Kennan subcommittee, but in a way that ensured public protection for clients who end up being represented by the paraprofessional. But you'll see a lot in what I show you as our recommendation, how that philosophy really sort of pervades through. And we, I do want to say about the JVCC, JVCC, it's written wrong here on the screen, but is right in my head. That we looked at their regulatory process a lot as an analogous regulatory process. So their rules, which are quite extensive, did inform our recommendations as well. So we looked at several areas, and I'm going to go through each of the areas that we are making recommendations, that the working group is making recommendations on. And the first one is that we all want these individuals to be qualified. And so we have drafted a rule here that talks about qualifications. And it was important to the subcommittee, and I think adopted by the working group, that this would be qualifications that include both education and experience. I think as lawyers, we want to know that we can have a highly educated paralegal, you know, is a baby paralegal and really can't do. And we've all had the paralegal who's does not have a degree, but has been doing this for 30 years and could run circles around us as lawyers. So it was really important to us that these recommendations include a combination of both experience and education as a means to qualify to be a paraprofessional. Our actual qualifications, I'm not going to go through each one. They are borrowed heavily from the paralegal division of the State Bar of Texas, because we had them in Texas. They seem to be worked. We tweaked them a little bit, but somebody has done the work and it's been working well for being eligible to be a member of the paralegal section of the State Bar of Texas. So that's where we started. And then in addition to a general qualification, you'll see, in addition, then we want these candidates to have specific criteria in the subject matter that they're being licensed in. So as Kennan said, these are licenses that would be, you have a license to be a family law paraprofessional. You have a license to be a consumer law paraprofessional. So our requirements are going to track Kennan subcommittees, like areas, and they would have to have experience in that particular area. As laid out in here for which is basically like last 3 of the 5 years, or you're already certified. So paralegals right now can be board certified just as lawyers are in certain areas of the law. And so if you're already board certified by TBLS, you're way better than the criteria, or way more experienced than the criteria here. And so that is a criteria that is specific to the subject matter of that. We did define what a paralegal is. I think we've all had experience where we have a legal assistant that is called a paralegal that may not actually do substantive legal work. So in determining your eligibility criteria for experience, we have to find what it means to be a paralegal as opposed to, say, a legal assistant. And that includes what is substantive legal work. So that's, if you'll just scroll down, and then that is all included in that. And that's it for the criteria. We have recommended, after much debate, that paraprofessionals do take an exam before they would be qualified to obtain a license. It was a pretty heavy part of the subcommittee's conversation about whether exams do actually test core competency or not. But ultimately, we decided that there would be an exam that is being recommended to the commission. This includes both a 1 hour exam on the substance of your license, whether family law, et cetera. And then everybody would have to pass also ethics type exam that would include your understanding as a paraprofessional about the limited nature of your license and when you need to, as Ken would say, a stop order to pass that along to a lawyer after you've exceeded the scope of your examination. The competency exam, the substantive part of the exam, can be waived if you already are board certified, meaning you've already taken the exam as a Texas board certified paralegal. And also there are two national organizations that have quite extensive subject matter specific exams that would also allow that exam, just the substantive part of the exam should be waived. I can take the ethics part of the exam is what the scope of the license is and whatnot. We do recommend that there be a character and fitness portion of the application process. That we got great information from the board from BLE on what that would entail. This is there is attached to this that we're not going to show you is the model character and fitness application that would be, but it just basically is looking at your past employment, past employment, past education, have you been disciplined in another area, where you've been licensed before. It's just some basic character and fitness. We're hoping that it is nothing like, at least when I did the character and fitness application when I was coming in, that was quite an extensive process. We're hoping this is a sort of character and fitness light. And then going down 10. We have recommended a code of ethics. Again, like I said, Ellen Lockwood was a member of our subcommittee, and she literally wrote the handbook on paralegal ethics. She was a great resource for us. There is a national paralegal code of ethics that we were able to draw from, so we did not write these like ourselves. We had multiple sources in which to recommend this code of ethics. And again, I'm not going to go through the whole code of ethics, but it is adopted from existing sources with some modifications of issues that would be raised specific to an unsupervised non-lawyer individual representing clients. So we've tweaked it a little bit, but it is the source of it is definitely an existing document. We anticipate that paraprofessionals will be licensed annually. So that they would be paying as much like lawyers, but ideally less than lawyers, because again, these paraprofessionals are going to be serving the low income population only. So we can't make the entry fee for them to get their license be too great given the clientele that they'll be serving. They'll have continuing legal education requirements, much like lawyers do. And then importantly, reporting requirements that would make would require the paraprofessional to self-report any discipline or sanctions or anything that happened that would call into question their ability to serve as a paraprofessional, but also perhaps as importantly too, for us to have a greater understanding about the effectiveness of these programs. It would require annual reporting of who they're serving and how, and perhaps reporting on should this program be expanded? We're sort of baby stepping this, to be honest with you about this. So the idea would be, where would you see further need? When did you have to turn away clients that had needs that but the idea is that in this annual reporting, we would be collecting data on the paraprofessional program to know, is it effective? Is it working? Are there problems? Can can or should it be expanded so that the court has that information as it continues to study this. I think the rest is, yeah. So that is the gist, a very short gist of the program, and as we get into the discussion this afternoon about it, I'm sure you might have more detailed questions, but I can get into the detail of those. But I just wanted to get a general overview of the regulation that we're contemplating for paraprofessionals. We will also, the working group has recommended that community justice workers also be registered through a similar program, but not near as rigorous a program, because community justice workers, remember, will be supervised by lawyers, but but again, we want some kind of registration process so that we're tracking and them as an individual to evaluate the effectiveness of the program, and also collecting data about areas so that the court has better data too on how and where and when community justice workers are looking. So that's all part of the working group's regulatory recommendations for paraprofessionals and community justice workers. And I believe that Justice Massengale is going to talk more about the same body that we're contemplating regulating NLOs. And with that, I will turn it over to you, Judge Massengale.
Great. Thank you, Lisa. Oh, sorry for me to be somewhat tech savvy, so I'm going to try to make myself efficient. And so I've got some notes that I'm sharing, but I'm also going to try to give everybody references to our formal report as I present this morning. First, I want to say Lisa's correct as a matter of historical fact and chronology. I let Kenan and Lisa have first choices of their subcommittees, but I was honored to have been asked to work with Kenan and Lisa on this very important project. I want to commend the court's leadership and courage in asking the Access to Justice Commission to study all of these subjects in the court's charge. In the interest of time, I hope you'll allow me to echo all of my colleagues' eloquent expressions of gratitude and appreciation for all of the support and all the feedback that we have received. So I'm going to start now to present our working group's proposals for rule modifications to create a pilot program to permit a limited exception to disciplinary rule 5.04 and permit firms that are owned in whole or in part by non-lawyers to provide legal services that are needed by low-income Texans who currently can't afford it. The basic expectation of such a rule change is that by permitting non-lawyer owned firms, which are sometimes called NLOs, by allowing them to provide legal services on an experimental and limited basis, we would hope to see new innovations in the legal market that would offer to serve low-income clients at rates significantly below traditional rates for similar services or at no cost at all, thus supplementing the options that are available through legal aid and pro bono service, and providing a new and complementary avenue to expand the availability of civil legal services for those who are currently unable to afford a lawyer. I want to start with our Constitution, go back to the letter, the Supreme Court's charge. Kenan shared that with you earlier. I have excerpted what's relevant to this part of our work. The court requested that the commission examine existing rules. The court requested that we propose modifications that would allow non-attorneys to have economic interests in entities that provide legal services to low-income Texans while preserving professional independence. Also asked that we should consider whether to recommend that these modifications be studied through a pilot program or a regulatory sandbox, and whether modifications should focus on certain services for which there's a particular need. I've rephrased this just into elements so that I can keep track of are the necessary elements of a proposal to the court that would be responsive to the letter. And it would be a recommendation for a rule modification that must enable non-attorneys to have economic interests in entities that provide legal services to low-income Texans. It must ensure that professional independence is protected. It must attempt to address the civil justice gap and expand access to justice for low-income Texans. And we should incorporate our recommendations about whether to study this through a pilot program or regulatory sandbox, whether we should recommend focusing on services for which there is a particular need. Let me introduce to you the members of the subcommittee who I have the pleasure of working with on this project. I appreciate all of their input. They're identified on page 37 of our final report. Want to particularly acknowledge that we had some great academic firepower assisting us. Professor Susan Fortney, Professor Nate Jefferson, both gave us great substantive input on our report, and I'm grateful to all of our subcommittee members for their efforts. Also want to take a moment to talk about our process. We have 8 subcommittee meetings. All of those meetings are listed and described with some more detail at pages 37 and 38 of the final report. The report links to our meeting recordings, minutes, agendas, all other materials that were circulated in connection with these meetings, including, I'd like to point out, by the time we got to the 3rd meeting, well, we started with organizational ideas and brainstorming, and it was a little hard to think about sort of how to approach the project and how to proceed. We didn't really approach it in terms of taking lots of votes like we heard Kennan describing. With the assistance of the National Center for State Courts, we developed what I call a working document that tried to assemble a lot of information, background information about the rules we were studying, what was happening in other states, and the things we were being asked to study. And if anybody has the desire to do so, you can go back through our book and see that we had an evolving working document that between each meeting evolved to incorporate what was being discussed in the subcommittee meetings, the feedback we were getting from outside our subcommittee, and the ideas and information that we were developing over the course of our work, such that by the end of the project, we approved the final version of the report as reflective of our work. So the main rule at issue is Rule 5.04 of the Texas Disciplinary Rules of Professional Conduct. Appendix G of the final report contains our research about the rules we were about to study because they're implicated by the rule proposal. Rule 5.04 generally prohibits sharing fees with non-lawyers, forming partnerships with non-lawyers to provide legal services, or practicing law at a for-profit company that is owned or controlled by non-lawyers. The unauthorized practice of law is also implicated by these rules that we were studying. And so Appendix G also discusses the rules concerning unauthorized practice of law and rules that prohibit lawyers from assisting the unauthorized practice of law. At pages 14 through 16 of the final report, we summarize the experience of several jurisdictions that have altered the traditional rule and permitted non-attorney ownership of firms that provide legal services. The ones that are most prominent because of recent developments are Arizona and Utah. Notably, none of these jurisdictions have approached this project or this concept the way that we have studied it, in the sense that our study has been truly focused and limited on achieving access to justice objectives. That is not, although expanding access to justice is cited as a reason for reform by other jurisdictions, none of these jurisdictions have made it sort of the leading or exclusive concern or purpose in enacting the reforms. And so what we have studied and proposed is different than anything that's been done in any other jurisdiction. The report at those same pages 14 to 16 also provides citations to empirical research that's been done about the kinds of innovative services that are being provided in these jurisdictions as a result of the reform efforts. Because Arizona, Utah, and other jurisdictions are not exclusively focused on expanding access to justice, many of the firms that have been started in those states don't have any obvious objective of providing legal services that might be needed by low-income clients. But some do, and we've described some of those in the report. Some of them provide services in areas like immigration law, family law, estate planning, that are areas that are needed by low-income Texans. My favorite example to share is Rasa Legal. We were privileged to have Rasa's founder, Noella Sudbury, share her experience with our subcommittee. For $12, Rasa will determine whether a client has records of a Utah criminal conviction that is eligible for expungement. And if so, for $500, Rasa will secure up to 3 expunctions. Now, that service and rate is available to anyone. But Rasa also works with partners to provide its services for low cost or no cost to eligible clients. So it's very easy to imagine spending more than $500 to hire a lawyer by the hour to assist with getting expungement. By offering an equity stake in the company, Rasa was able to recruit the tech talent that was necessary to develop and implement its platform. And of course, for those who are eligible, clearing a criminal record can be a very important step towards rehabilitation and becoming a productive part of society. And I just saw in the last couple of weeks, Rasa has recently announced expansion of their service into Arizona, and they can do that because of the reform in Arizona. I'm now going to turn to the substance of the working group's proposals. The working group's proposal includes 2 tiers of rules. One tier, it consists of a proposed Supreme Court order that would create a pilot program under the auspices of the Judicial Branch Certification Commission, the infamous JBCC, and then a second tier consisting of the guidance provided and to be provided and implemented by the JBCC. And just to say an additional word about why we settled on the JBCC, it is administratively attached to the Office of Court Administration. It has a pre-existing framework that could administer the approval and oversight of these NLO entities. And the Texas Supreme Court already has statutory authority to assign regulatory programs to the JBCC. So this is why it seemed like a natural place to place this program, although conceptually, all of these proposals could conceivably be put in some other different regulating entity if there were a reason to do so. So I'm going to go to the first tier first, and this is our rule proposal for a Texas Supreme Court order. You can find it at pages 53 to 54 of the final report, and also in Appendix A. It is a big block of text, and I'm going to break it down for you. Starts off with a statement of purpose. The purpose is to expand civil access to justice for low-income Texans. We have made a concerted effort. We've made a concerted effort to keep this essential motivation and purpose at the center of every aspect of this proposal. Next, this proposed order delegates authority to the JBCC to establish qualifications for firms to provide a specified scope of approved legal services. Now, I'll discuss those qualifications more in the second proposed tier of regulation. But the key point here is that the approved firms cannot provide any services they want. They only can provide services that have been specifically approved. Next, the proposed order would provide that the entities that are certified by the JVCC may be issued a license to practice law and thus become considered a member of the bar. This is designed to bring the pilot program within the scope of rules that prohibit unauthorized practice of law. Essentially, services within the pilot program will become authorized practice of law. So the order states explicitly that the provisions of Rule 5.04 that prohibit non-lawyer ownership of firms will not apply to firms that have been certified by the JVCC and are acting within their approved scope. Next, the order states explicitly, certified and licensed entities must provide legal services to low-income Texans. And they must satisfy any other conditions that are required by the JVCC. This ensures that the only kinds of legal services that will be approved by the pilot program will be those that low-income Texans actually need and actually use. Finally, the order requires annual renewals of licensure. This will allow the court to keep the pilot program on a short leash, modifying it over time based on data and experience. And presumably at some point, the court in the future would assess whether to end the pilot program, either by ending the experiment or by adopting a permanent change informed by what will have been learned through the pilot program. Next, I'll address the second tier of rules that we would propose to be refined and implemented by the JVCC. Now, given the scope of this study and our time constraints, we did not try to propose a fully realized set of proposed regulations. Instead, we developed a list of recommendations for further study and consideration by the JVCC and any advisory board created to implement and oversee this program. Incidentally, one of the additions that the working group made to our subcommittee's proposal was the suggestion that the advisory board should be composed of at least the majority of Texas licensed attorneys. As I get into this, I think the best summary of the proposals is on page 51 of the working group final report. And when we get to the time for the commission to take action, I'm going to propose using that summary on page 51 as the baseline for our recommendation to the court. There are some other proposed details on pages 55 and 56. The version on page 51, I think, best reflects the nuances that were added after the working group had its discussion. So the proposal contemplates that there will be an application process that will entail robust disclosure about any applicant firm and what its proposed services will be. Those mandatory disclosures to the JVCC would include the scope of the proposed legal services, who the intended client base would be, including how this entity is proposing to satisfy the requirement of serving low-income clients. They'd be required to disclose how their proposed legal services will increase access to civil legal services needed by low-income Texans. They'd be required to disclose their proposed funding model, including their fee structure for clients. We also suggest that the entities, as part of their application, be required to provide a form client engagement agreement and how they propose to notify clients of the conclusion of an engagement. We would require disclosure of ownership and management structure, identifying the level of participation by non-attorneys, identifying potential conflicts of interest between the entity's owners, and proposed legal services. As we'll discuss in a little more detail in a second, we would require specific written protections for attorney independence within the entity. And a plan for discontinuation of the entity, or its certification, or the pilot program. I got a question about this morning. What happens if it's ended? We've already thought about that. We are requiring or proposing to require that these firms have an exit strategy if they lose their certification or if the program is ended. In addition to these disclosures that are required as part of the application process, we've also recommended a robust set of mandatory obligations that these entities would take on. First of which is adherence to ethics rules that govern the legal profession. As Lisa mentioned, there is a sentiment in a lot of this reform movement to try to decrease the amount of regulation. We did not suggest that these NLOs have any lower standard of ethical obligations than what apply to lawyers who provide legal services. We also would require regular reporting to the JDCC and consent to monitoring of the entity's programs to ensure that quality legal services are being provided, that they're being provided at low or no cost, that they're being provided in compliance with ethics rules, and that clients are not being exploited, or that inferior services are not being delivered that cause more harm than good for this community of low-income Texans who need help. We would require prominent disclosure of the facts of non-attorney ownership or management, both to the clients and to the public. We would require that these firms identify their internal compliance officers who would be required to be Texas licensed attorneys who are responsible within the organization to ensure that these obligations are being met. An idea that came directly from our working group was that they should commit that legal advice is not going to be rendered by generative AI. It's going to be rendered only by licensed attorneys or paraprofessionals. We would require that these entities inform their clients about how to lodge complaints with the JDCC. We would require them to affirmatively seek feedback about their services. As some other states have done, we would require collection and reporting of data about client demographics so that we can evaluate the effectiveness of the pilot program. So we would want them to collect data about client income, legal services provided, the fees, if any, and the objective outcomes of the services. We require these entities to commit not to seek or accept funding that would take away from the good work of our legal service and legal aid organizations. We have them commit not to deplete our limited funding that we receive from state or federal government entities or from the Texas Access to Justice Foundation. And we would require disclosure of whether the entity carries malpractice insurance. Now, we would expect the JDCC would exclude certain kinds of practices or legal services that it may determine are unsuitable for the non-attorney owned service model. And that may develop over time based on the experience of evaluating the different kinds of proposals are made. One example is that contingency fee arrangements might be excluded. There doesn't seem to be any reason to think that traditional service models aren't already fully meeting the demand in that respect. At the subcommittee level, we received reports from and had engagement with representatives of family law, immigration law, and tax law practitioners. That input is summarized at a very high level in the report at pages 57 to 61. But the full text of the reports that we received from them are included in our materials at Appendix B. And while our working group did not propose to impose any per se exclusion on these or any other practice areas, There likely are good reasons to restrict the types of services in these areas that may be suitable to be approved in the pilot program. We would anticipate that the JVCC would engage constructively with subject matter experts to develop guidelines to exclude types of legal service if there is a genuine, non-anti-competitive reason to do so. Now, the court specifically asked us to consider protection for attorney independence, appropriately so, because that has been the traditional justification to have a rule like 5.04 in the first place. Fortunately, there's been a lot of research on this subject in the context of studying multidisciplinary practice. That research was discussed in the report, pages 61 to 62, with some citations to very helpful resources. We are not suggesting that each and every idea that we've compiled in our report all be implemented. It's more like a menu of options, but there are a lot of ways that can be implemented to get entities to commit in writing to commit to protecting the independence of attorneys' professional judgment. We would recommend that there be an annual review of those kinds of procedures, that there be an annual certification of compliance by the entities, consent to administrative audits, and then a great idea that came out of our subcommittee process is a different kind of approach called proactive management-based regulation, or PMBR. This, instead of approaching rule compliance from the standpoint of identifying violations and essentially prosecuting them, PMBR is a process of self-assessment for an entity to determine if it's got effective systems in place. If an entity reports that it's fallen short in this area, the regulator can work with the entity to achieve compliance. And so this is a sort of constructive way to encourage entities through self-assessment to improve their operations. One very important question that was addressed by the working group where we didn't reach a consensus is how to measure an entity's proposal or its performance to evaluate whether it is adequately serving low-income Texans to justify its inclusion in the pilot program. Our members were generally proposing that the entity must satisfy some minimum percentage of clients that qualify as low-income Texans. In our subcommittee, we discussed a range of possibilities from 20 to 80% of clients being required to qualify as low income. At the working group level, one member proposed it should be 100% low income clients. Others thought that a restriction to only low income clients would significantly reduce the possibility of attracting innovators. To go back to the ROTSA example, part of how they can provide that service and provide it to some at a low or no cost basis is that some clients can and are willing to pay $500 for the same service. A roughly equal number of the working group favored giving discretion to the JVCC to evaluate the proposal and exclude those that are not likely to expand access to justice for low-income Texans. So to loop back to the elements of the charge and what they've asked us to recommend to them. What the working group has proposed is a pilot program that would enable non-attorneys to have economic interests in entities that provide legal services to low-income Texans while providing professional independence. We have throughout the proposal included multiple checkpoints to ensure that the entities that have such approvals would be providing specifically approved legal services that are services that will expand access to justice for low-income Texans. With respect to a pilot program or a regulatory sandbox, we didn't discern any difference between those two concepts, but we do recommend that it be done through a pilot program, and that on this question of whether modifications should focus on services for which there's a particular need. You could read that in a couple of ways. We certainly believe it should be focused on services for which there's a particular need by low-income Texans, and that's an important criterion. But to the extent that might have meant, should the program be limited to specific predefined areas, we did not think that that would be we would not recommend doing that specifically because we did not want to prejudge and predetermine where the areas of innovation might be, but instead allow the regulator to have the flexibility to evaluate the proposal as they received it. So that is the summary of the working group's recommendations. Subject to the commission's discussion, the public comment will be hearing during a moment. Any modifications that the commission may see fit to make after our discussion. I anticipate moving the adoption of the working group's recommendations in 3 pieces, similar to the questions that were posed in the working group survey, which is at Appendix D. First, by moving adoption of the working group's recommended rule modification to establish a pilot project to provisionally establish an exception to Rule 5.04 for entities that are certified and licensed to perform a defined scope of legal services. And that pilot program would include an application procedure and rule guidance to ensure that the approved entities actually provide needed services to low-income Texans, including the features described in the summary on page 51 of the working group's final report, as those might be modified today by the commission. Secondly, I anticipate moving adoption of the working group's recommendation that the pilot program be administered at the direction of the Texas Supreme Court and overseen by the JBCC, which would establish an advisory board comprised of at least the majority of Texas licensed attorneys, and the advisory board would establish policies and procedures and oversee the application process and review demographic data about the clients who are receiving the approved legal services. Third, it's my intention to move that the commission recommend that the JBCC and its advisory board be entrusted with responsibility and discretion to evaluate applications on a daily basis to determine whether the proposed legal services, in light of all information provided in the application and review process, presents a sufficient likelihood of expanding access to justice for low-income Texans to justify allowing that entity participation in the pilot program. That concludes my report, Chair Meyer.
As you can tell, the amount of work that has gone into these reports is immense. And I think that appropriate that we thank the working group. Many of you are here, but many of you are not. But if they're watching, we want them, each and every one, to know how much we appreciate the work. In addition to our commission members, our court liaison, and the co-chairs. We are prepared now to move into accepting comment from the public in connection with this report that you have just heard. If there is one motion, I know we've got 100 gets in there. That is rude. Maybe we take a 10-minute break. Please come back as soon as you can, so we can resume, because we are running over.
Well, thanks for being prompt in your return from our break. We have a number of folks signed up to speak. I hope that we'll be able to do this efficiently. I will be the timekeeper and let you know, or Harry will let you know when your time is up and you must stop. We're going to try to be very efficient so that when the first speaker finishes, they will take their seat and we'll ask the third speaker to then come up while the second speaker is speaking, and we'll try to go as quickly as we can so that we can accommodate everyone who wishes to make comments this morning. The first 2 speakers are already seated. They are Jonathan Bates, he'll be first, and then David Chamberlain will be next in person. I do want to inquire for those that are joining us online, if Charles Whittier Jennifer Broussard or Amy Esterby are planning to speak, we have you listed as tentative. And so if you do wish to speak, if you would please respond electronically through the Zoom call there to let us know that you are going to speak, then we will elevate you from webinar to speaker status so that we'll be efficiently able to accommodate you as well. If you're not going to, then you need not notify us.
What
We'll
is the
just
time
keep going. 3 minutes. All right, Mr. Bates, your 3 minutes will begin now.
Thank you for allowing me to speak today. My name is Jonathan Bates and I'm a family lawyer. Texas family lawyers support helping low-income Texans. For many years, Texas family lawyers have led all practice areas in pro bono services to low-income Texans. It was my honor to serve on the working group, scope of practice subcommittee, and the family law subgroup. The paraprofessional recommendations before you were approved in multiple meetings of the working group. Those recommendations have the support of family law leaders. They were crafted working closely with Justice Busby and have a laser focus on helping low-income Texans and avoiding harm. I urge you to approve them. I disagree with the characterization of the working group on non-attorney ownership as being recommendations because they did not pass a vote of the working group to come to you today. In fact, the one vote that we had on the recommendations failed by a vote of 6-3. Family lawyers overwhelmingly oppose non-lawyer ownership, and frankly, every lawyer I've talked to opposes non-lawyer ownership. When we've talked about what the potential terms for implementation might be, family lawyers have responded that the proposals should be exclusively focused on low-income Texans. We were told that the changes cannot focus solely or even primarily on low-income Texans because then the non-lawyer ownership would surely fail. I ask you, if non-attorney ownership proposals are not focused on low-income Texans, then why are they even a discussion for the Access to Justice Commission? If the proposals are not focused on low-income Texans, and it is not reasonably foreseeable that the proposals will actually help bridge the justice gap, then why are we discussing making fundamental changes to our legal system in the name of access to justice? The only present examples that we have heard are that there are going to be potential for name changes that will be cheaper for adults, and then this concept of the expungements. Well, I would suggest to you that reduced cost criminal expungements and adult name changes do not sound like a sound reason to fundamentally change our legal system. I have not heard anyone actually point to money that is sitting on the sideline where a benevolent business entity is somehow being prohibited from helping low-income Texans under our current system. The ones kept on the sideline are entities with a profit agenda, and they should remain on the sidelines and seek their profit elsewhere. I thank you for letting me speak. I ask that you approve the paralegal proposals and that you vote against the non-lawyer ownership proposals. Thank you.
Thank you, Mr. Bates, and thank you for your service on the working groups. Is Mr. Chamberlain present?
Thank you, Chair. And I want to thank all members of the commission for all the hard work that you have done. And I am David Chamberlain, Chamberlain McCaney in Austin, Texas. I'm here speaking on my individual behalf and also on the behalf of the Texas Association, the Texas chapter of the American Board of Trial Advocates. Former president of the Austin Bar Association, former president of Texas BOTA, former president of Texas Association of Defense Counsel. And notably, I would point out that I have served as chair of the Austin Bar Foundation, and I'm a lifetime member, senior lifetime member of both the Austin Bar Foundation and the Texas Bar Foundation. And like Jonathan, we do support the paralegal aspect of this, and I want to limit my further comments here to NLO or non-lawyer ownership of law firms. Let me point out that our profession has done a lot, and it's doing more every day to support legal services to low-income Texans. Just this morning at 9:04, I received an email from the Texas Bar Foundation seeking applications for grants because the Texas Bar Foundation plans to give out yet another $1.6 billion to delivery of legal services, either in terms of projects or other organizations that are focused on the very things that we're talking about. Every major metropolitan area in this state and some others have either pro bono or volunteer legal services to the poor. Volunteer legal services in Central Texas, Dallas, Houston, Amarillo, Fort Worth, San Antonio, all have these organizations that are working very, very hard. As Jonathan said, if there's money out there sitting on the sidelines, and these organizations that exist need that money and need these resources, instead of what we're talking about today. NLO is not the answer to this question. You've heard mention of Arizona and Utah. Those things have not been successful. They have been populated by litigation funding companies, private equity firms, hedge funds, and others. And they have not ended up moving the needle whatsoever as far as delivering the legal services to deserving low-income Texans. Now, you heard at the end of Judge Massengill's report that this thing is not limited, okay? It's not limited to low-income Texans. It is not limited to the kind of legal services that can be delivered. So in other words, the door is open, subject to board approval, I suppose, on, delivering corporate legal services, contingent fee legal services. And quite frankly, this is a blatant attempt to get litigation funding companies involved in this, either directly or through, directly or through a referral service. So again, thank the commission.
Thank you very much. And Ms. Sharp, you would be next, and Mr. Richardson next.
Thank you. My name is Laura Villages Sharp, and I come here as an individual. I am also currently the president of Austin Abota. I have formerly served on the Austin Bar Association board for nearly 3 decades. Only recently have I rolled off of that. I also spent 10 years in the House of Delegates for the American Bar Association representing Austin, and 3 years on the board of governors for the American Bar Association, representing all Texans in Florida in that body. The ABA and Abota strongly oppose any changes to non-lawyer ownership. Separately, I sue professionals for a living. That is my job. I have also represented professionals for a living in my former job. And as part of that, I am well aware of what can be a sword and shield on these issues. When you consider bringing non-lawyer professionals that are regulated separately and differently from lawyers into the mix, and say that they can disclose that they don't have malpractice, it is not a matter of if, it is a matter of when they screw up. A lawyer suing these places, if you can get a contingency fee attorney to take a suit against somebody that does not have malpractice insurance. So somebody goes to a profit corporation and spends $500 to $1,000 that they may or may not have. And then to find out that the fix is going to cost them something increasingly more than that. That is just not good thinking. So there is no protection for consumers in this plan if you allow non-lawyer ownership of law firms. In addition to, I think you'll hear about the independence of the practice. I would strongly oppose that this be an issue. The paraprofessional program, pilot program sounds great. I think that we should conduct our inquiry there. But if our goal is for low-income Texans to get care, we need to do it through our volunteer organizations, through our increased ability to fund these things, and through the paraprofessional program and not non-board ownership. Thank you.
Thank you very much. And Mr. Richardson, we're going to take Mr. Younger first, who is on.
Stuart Matthews. Stuart Matthews is up first.
Okay, Stuart Matthews, I'm sorry.
Can you hear me now?
Mr. Matthews, please make comment.
Okay, thank you. I appreciate it. Can you hear me? If you're able to hear me, I need to indicate that none of the studies,
Mr. Matthews, can you hear us?
I can. Can you hear me?
Mr. Matthews, if you can hear us, would you please indicate in the chat that you can hear our audio, please? We're gonna work on that technical, he says he can hear us. We cannot hear you, sir, so could you make sure that your audio is working on your end?
Can you hear me now?
I'm not sure we have some.
Well, we had the sound people check it out this morning. It seemed to be working, so
Can you hear?
Pablo says he can hear him, but we can't, so the
Yeah.
problem's at our end.
Can you hear me?
Okay, well, let's move on to a couple of the folks that are actually present in the room while we troubleshoot the sound issue. Thank you all for your patience.
Ms. Richardson.
Can you hear me now?
I'm loose, but I'm happy to yield the floor to Mr. Richardson.
Well, no,
Mr. Newsom, I don't have number 14.
okay, Tim Newsom.
Oh, okay, gotcha.
Thank you. My name is Tim Newsom. I'm the president of Texabota. I am a past president of the Amarillo Area Bar Association. I sit on the executive committee of the Dallas chapter of Texabota. I'm also a member, a life fellow of the Texas Bar Foundation and a senior fellow of the Boda Foundation. I've also contributed routinely to the Amarillo Area Bar Foundation. I'm here to speak today on behalf of Texabota. These are also my personal beliefs as well. I think everybody here knows what Texabota is, but briefly, even in the time I have, we have 1,400 members. They're all members of ABOTA, the American Board of Trial Advocates. That is a invitation only association of lawyers from both sides of the bar, plaintiff and defense. And we stand united with the Texas Trial Lawyers Association, Texas Association of Defense Counsel, in saying that we favor affordable legal services to the poor. I say that without any fear of contradiction. We oppose non-lawyer ownership of law firms. We should not open the gates of the bar to allow in non-lawyers. All of us that are lawyers, the day we took the oath to be lawyers, had to say that we would discharge the attorney's duty to the attorney's client to the best of our ability. Allowing non-lawyers into the bar would result in a divided loyalty. Lawyers, as we took the oath to do, and as we do, we have a duty to our clients and them alone and nobody else. Businesses, on the other hand, non-lawyers on the other hand, their duty is to bring a profit to the shareholders, bring a profit to the owners of the company. It is at the core of allowing non-lawyers to come into the bar would result in a divided loyalty, would result in the things that Ms. Sharp spoke about just a moment ago. Divided loyalties are a carte blanche and per se breach of fiduciary duty. We have heard quite a bit today about the work that's been done by the working groups, the committees. It is a tremendous amount of work, and I commend them for that. But it's only been work that's been done over a period of 10 months. We would be the first state in the United States of America that would allow non-lawyers to come into the bar, because no one else has done it before
based on the studies that have been done to help legal services for the poor. And the only states that have done it have been Arizona and Utah. Texas has got a population of 29.5 million people. Arizona's got 7.26, about the size of Dallas-Fort Worth. Utah has 3.3 million people. Texas has 108,000 lawyers. Is that my time?
That is. I
Chair.
like that it's a sound, and then you don't have to hear the sound of part of it.
Very much,
No.
appreciate it very much. Would you please say your name?
Absolutely. Thank you, Chairman Myers. My name is Jack Walker. I'm the Vice President of Legislative Affairs for the Texas Trial Lawyers Association and the President-elect. TTLA is opposed to both of the recommendations of the working group, and I want to talk about both of them today and tell you why. I first want to thank the commission for all the hard work that you've done. Sitting here today through the presentations, truly appreciated all the work that went into the report and recommendations. However, I want to first talk about NLO. I've got a son that's about to graduate from law school. He's going to get out in May and take the bar in July. And I think about the future that he has as a lawyer and in a profession that we love. Opening the bar to NLOs threatens that future. Opening the bars to NLOs will diminish what we all hold sacred, and that is our oath to our clients. Here's why. Legal services is a great name, but legal services are not commodities. You can't profitize legal services. Legal services is a profession. And when you go look at the 4 areas that has been identified by this group as in need, low-income Texans need help. They are family law, housing, consumer debt, and probate. And Judge Massagill was pointed out that 2 of those, there are even suspect of whether we ought to be looking at NLOs to be doing all of the areas that they need in family laws, child custody, in housing, it's eviction. These are all representations in court that need to be handled by lawyers. And they need to be handled individually, and they can't be cookie cutter. And so NLOs and allowing non-lawyers in when you're going to try to profitize legal services as a commodity doesn't marry with the goal of this group, and that is to provide legal services to low-income Texans. It doesn't very good. And so we would ask you to tap the brakes. Let's look very carefully before we do this. It's going to be paradigm changing for our profession. And if you look at Arizona, so there's an exhibit to the report, and it's the Arizona, the folks that did in Arizona. Run down that list. It's scary, okay, because it's not low income stuff. It's bigcarwrecks.com. It's private equity firms. It's debt refinancing firms that are going to prey on folks. This is a danger, and I just want this group to understand that don't change the paradigm. Don't hand the keys to our profession to profitizing our profession as a commodity. Number 2, I want to talk just briefly about the paraprofessionals and what we're concerned about. I talked to some legal aid lawyers, and I think those that have done legal, it's going to run out of time. But I really appreciate your opportunity to talk to you.
Thank you very much. And yeah.
Good afternoon. My name is Gloria Leal. I'm a lawyer here in Austin, Texas. I also do administrative law and government relations. Like the speakers before me, I do have a couple of credentials, but I'm going to focus on the credentials dealing with my service to the Hispanic community. I'm past president of the Mexican American Bar Association of Texas, which has like 7 chapters in all the major cities. I'm also the first woman general counsel for National LULAC, the League of United Latin American Citizens, the largest organization, the Hispanic organization in the state. First of all, wearing those 2 hats, both groups oppose the non-lawyer access to ownership in law firms, which would set up a separate regulatory system for non-lawyers to practice law and provide legal services in areas currently represented or that total practitioners primarily practice in. Okay, we oppose that. Secondly, providing legal services by these non-lawyers to the low income is discriminatory to the poor who are entitled to be represented by legal counsel. And if you open it up to non-low income, as previous speakers have said, creates a problem. It's problematic. And secondly, or thirdly, no one has actually stated how this proposal, which creates a dual regulatory system for non-lawyers, is going to be funded. No one has talked about the costs. The fact of the matter is that appropriations to the Supreme Court, to the JBB, to the Office of Court Administration, that will be funded by the legislature. And therefore, you will have to make a presentation to the legislature at some point about the system and justify the cost for doing this when there's so many other needs. But with regard to the Advocates for Justice, we support y'all. Thank you for all your work, but we have some concerns. One of them is there is nothing in any of y'all's presentations or the report that talks about the impact on the non-Spanish, non-English speaking Texans, the Hispanics. Not one mention of it, okay? You talk about access to Texas. Is that going to include non-documented Texans? No mention about language services, etc. No input hardly. I went through the list of who y'all access for input. I don't see any indication that any groups or any Hispanic bar groups or Hispanic groups were contacted for him. Okay, this don't happen. Okay, so I ask you to take my concerns into consideration and not table, but maybe wait a minute before you proceed with these proposals. Thank you very much.
Thank you. And, is this, what's the name? Or no, Steve?
No, State President.
Yes, go ahead, Steve.
Who goes first? Okay, my name is Steve Bresnan. I'm here to deliver some expertise, not on behalf of any particular group today, although many of you in the room may know that I represent various folks who are involved in various aspects of the legal profession, including the Texas Family Law Foundation. You'll have written a written statement on behalf of the foundation, so I won't be speaking on their behalf or the Texas Trial Lawyers Association, or even the Association of Dental Support Organizations. Did I get your attention? On page 50, footnote 83, there's a reference to that says dental support organizations which currently exist in Texas might act as potential model for what non-attorney investment might look like. I think it's very important to straighten that out because whole wars have been fought for a decade over what a DSO is and its relationship to dental practices. A DSO cannot own or have a financial interest in a dental practice. It must be owned by a dentist or a combination of dentists. A DSO can provide non-clinical services to a dental practice. Those services are, many of them are listed in the statute that's cited here, but every one of them is non-clinical. In fact, if a DSO were to, through its contract or any other relationship, influence the independent professional judgment of a dentist, it would be committing a felony. And so it's clear that that be understood. These services are sold to the PC, typically owned by dentists, is purchasing services from the DSO, and it's not, the PC is not providing services as an employee of the DSO. That's against the law. This is consistent with the separation that's described in Title VII of the Business Organization Code, chapters 301 et sec, that deals with professional entities, who may own those entities, and liability issues related to those issues. The entire structure related to the dental practice and the relationship between the for-profit DSO service provider is built around, preserving the independent professional judgment of the dentist. I think you can, first of all, that's entirely legal under current law. DSOs are not regulated except to the extent that they can't practice dentistry. Could be done, I think, I know of no reason why those same laundry list of services could not be provided to a law firm now or an individual lawyer now. I would urge you not to confuse the two, and my whole purpose here is not to fight the war again, because we've already fought that war. Just thank you very much. I'm always happy. A lot of y'all know how to get a hold of me. If I can advise in that regard, I'd be happy to do so.
Very much.
I'm Roy Petty. I'm the chair of the, I'm the former chair of the immigration section of the state bar. And I'm here today with Teresa Coles, who is the chair of the immigration section, and Justine Daly, who is the chair-elect of the immigration section. And we three chairs are very grateful that the subcommittees and the working groups invited us, that they allowed us to speak, that they allowed us to submit written materials. Our members submitted written materials. And we feel that our points were listened to and considered. And so we three chairs are grateful for the work of the committee and the working group. What I would like to mention is that I do want to point out that the working group's report recognizes that federal preemption precludes states from determining who may give immigration advice and who may file immigration applications. And that's because those areas are heavily regulated by federal rules, which are designed to protect the integrity of the federal immigration system. We three chairs are somewhat concerned about the JBCC being left to itself to determine what practice areas it could include in the future. Certainly, our points were considered because we were brought into the loop. We certainly would be concerned if the JBCC were to allow for the practice of immigration law by paraprofessionals in violation of the Sperry Doctrine and in violation of federal preemption. So that said, on something different, I would like to address something very specific, and that is the third sentence of proposed rule 504 and the rule for the JBCC in the first tier. And I would like to address that through an example. My law firm, we provide only immigration services. We serve low-income Texans, and that's low-income Texans that generally meet the 200% of the poverty level guidelines. And we know that because through immigration services, sometimes we have to capture that information. So we know that our clients generally earn less than 200% of the poverty level. Our clients generally are Spanish speakers as well who do not speak English. Reading very carefully the first tier rules for legal services provided by the licensee shall be limited to those proposed by the entity and specifically approved by the commission, it would appear to me that my law firm could apply to become a certified organization with the JBCC. And there may be a good fit there because I have clients who need low-cost, cheap divorces. If I were to get that certification, then automatically under the third sentence of Rule 5.04, my law firm would no longer be subject to the prohibitions on fee splitting, which would now mean that I could sell shares in my firm and I could share the profits from my immigration business with non-attorneys. Thank you.
Thank you very much.
Why don't you just check to see how the audio's coming? We made some adjustments. We still have the text in the building coming down to help us, but we just want to just try it. See how it's
going to have. Mr. Matthews, can you try and speak, please?
Can you hear me now? I can hear you.
It worked this morning. It absolutely worked this morning. To the rescue, we have Casey here to help us, so let's give her a minute to work her magic. Let me just check in and see if there's anyone else in person that is signed up to speak. Any of the folks in the audience that we have not yet heard from and called upon who have signed up before today. Steve McConnell.
I was number 17, I was told yesterday.
Tell me your name.
Caroline Bagnelli.
Yes, she was. Yes, why don't you join us at the table, Ms. Benelli, and we could take you while we're working on the audio. Thank you.
Thank you, ladies and gentlemen. I am here, Caroline Badanelli. I've been a trial lawyer for over 20 years. I practice in Austin, Texas, in the Central Texas region. I'm a member of TTLA and CATLA. I am also a member of the Lawyer Referral Services of Central Texas here, and I work and do cases with the Match Pro Bono program. I also do pro bono cases with BLS here and with RACES. And I am here to express my concerns about having paraprofessionals and non-lawyer entities offer services to low income Texans. Most of my practice is middle class and middle income Texans. I would much prefer that we direct our resources, time, and efforts towards the organizations and many others that I just mentioned and I work with, because I think that they do an excellent job of providing legal services and assistance to Texans. I also regularly consult with CPS attorneys on our docket system here who are court appointed and are very professional and very capable. My concerns, to give you some examples in the field, uncontested does not mean uncomplicated. We have a lot of, for good, which is good, cases now where we have 50-50 possession schedules. The problem is that I've seen these legal Zoom forms and decrees drafted by paraprofessionals. I had one where there was a summer possession schedule and no year-round possession schedule. That was interesting. I had numerous cases I had to come down because property division enforcement is simply not possible. They didn't make any provisions for qualified domestic relations or retirement. They didn't make any provisions for a house sale or doing anything about a sale of a house. And this really hurts most of our low and middle income Texans. Finally, I also do another family violence cases. Now I have extreme concerns about non-lawyers or non-legal entities helping family violence victims who are often coerced into saying something is uncontested when it is not. I have seen where people have given up all interest in house and retirement. I have, and this is largely women, this was the last protective order I received was for male, but I have severe concerns what will happen to our family violence victims in this state if they are handed over to lesser funded $500 a shot legal entities when up against much more financially capable organizations, attorneys, and parties. And I would hope that we would instead provide better ways to serve our Texas low and middle income people other than by providing the attorneys the state that's participating. Thank you.
Thank you. I think we've got our audio working now. Fingers crossed.
Yeah, Mr. Matthews, you can try again, please.
Can you hear me?
The voice of God.
I'm hearing a lot of feedback.
Yes, sir, we can hear you.
Very good. All right. I will say that this program is being touted as one to help low-income Texans, but what I see missing in everything that's been presented today is a look at those states and even the UK that indicate how this has helped the low income in those states. And the reason it's missing is because it hasn't. I would direct you to a Yale Law Review article or Yale Law Journal article by Stephen Young out of October of 2022, where he looked at this extensively. And it indicates that those programs have not helped low income, have not addressed the issues that this panel is raising to any means. Okay. It simply is not true that it'll help low income. And I'm talking about the non-attorney owned law firms. Instead, this program only permits a way for big companies to get inside of the justice system. And what we will see then is attorneys who will be beholden to the big companies instead of being beholden to their clients. And before you sit back and say, that simply isn't true, they still have an ethical duty to their clients, we can see this already happening whenever you have insurance companies that have in-house counsel that have a real difficulty even meeting all the demands because they have to meet a bottom line. You're going to see the same thing happen. And then you can also see where the progress, where law can be decided because an attorney cares about what is happening to the client. They will pursue a case to even change law. Instead, when big business is in it, they're not going to do that. They're going to have a bottom line that they have to answer to. Our concern here is not just simply because it might affect our income. That is not my concern at all. My concern is that this will affect justice to all Texans. My concern is that this is being billed as a way to help low income when the other states that have done this have categorically shown that simply is not true. If this program comes into play, towns, smaller towns that have attorneys that are working, that are well invested in the community, suddenly are going to be inundated by big box attorneys. Okay. We see that whenever you see the Walmart that has taken away the small home companies in those towns, the small businesses. You're going to see the same thing happen, and the care is not going to be for the clients. The care is going to be for the bottom line. Okay. How will this help Texans? I'm sorry, can you hear me still?
Yes.
Yes.
All right. How will this help Texans? It won't. This is going to hurt jurisprudence across the state. Okay, right now, attorneys can make money what they're doing, yes, but they also owe a duty to the client. If this comes into effect, the lawyer will owe a duty to Walmart or an offshoot of Allstate or an offshoot of.
Okay, we apologize, sir, but your time is up. Thank you for your comments. And I do want to ask if Mr. Younger is Minister, well,
Mr. Younger's online available.
okay, what about Mr. Drogi?
Not available.
Okay, great.
Morning, Mr. Younger.
Good morning. I'm Stephen Younger. I'm a past president of the New York State Bar and chaired their non-lawyer ownership task force. I'm also the author of a Yale Law Journal article on the perils of non-lawyer ownership that has been cited in your report. I want to thank the commission for allowing me to speak today. I am a huge supporter of tackling the access to justice crisis in America, but non-lawyer ownership simply does not do that. Lawyers, as you've heard this morning, and as you saw in the appendix to your report, overwhelmingly oppose non-lawyer ownership. They've opposed it not only in my own state, but in Florida, California, Illinois, and in the ABA. Why is that? It's because we have legitimate fears that our independent professional judgments will be compromised by non-lawyer owners. Non-lawyer owners are not trained in the legal structure, particularly not in ethics, and they can't even be disbarred. We have seen a concern with non-lawyer drafted wills, as you've heard earlier, and divorce settlements that just don't stand up. And we can't afford to have a two-tier justice system where our indigent folks are treated to consumer abuse. Now, I've studied carefully Australia, UK, Utah, and Arizona. There is not a single piece of evidence that there's been any movement in the access to justice crisis there. In Utah and Arizona, the overwhelming groups are wealth services providers, not helping our poor, or litigation finance groups in the personal injury sector. Not a single entity in Utah or Arizona provides services in court for the poor, particularly in areas like family law, housing, etc. In fact, many of them provide chatbots to service and give advice, not the kind of quality that we want. I would encourage you to consider some other alternatives. For example, in New York, we have our non-lawyer navigator program that helps people navigate the courts. We also have a program called LIFT that provides forms in numerous different markets. But I would encourage you not to turn the Texas justice system over to corporate America. That's exactly what non-lawyer ownership does. And it's something that would not be good for your state or elsewhere. Thank you very much.
Thank you, sir. And is Grace Weatherly available?
Yes, thank you. I apologize. I'm on the road for Abota today. I am the 2021 national president and the 2019 Texas Abota president. And I only mention these things because I don't want to echo what everybody else has said today, but I do want to emphasize that I've spent decades working for Legal Aid of Northwest Texas, formerly Legal Aid of North Texas, and also for the State Bar Lawyer Referral Information Service Committee, where we at one time did a lot of research on a modest means panel that would be a lower fee referral service. I say all that so that you know, I have a true heart for the provision of legal services for the low income Texan. I commend the commission, as others have, with all the hard work you've done. But the idea of even experimenting with a non-lawyer ownership of a for-profit entity to provide legal services could cause tremendous damage before you even determine the problem and shut it down. And what I'm talking about is access to client client information that right now is protected by the rules of professional responsibility, but also by Chapter 501 of the Texas Civil Practice and Remedies Code. And you would have people who do not have a fiduciary duty to the client have the, oh my God, they hadn't heard any of it. Did you?
Yes.
Can you hear me?
Yeah, we've heard every word.
Okay, okay, sorry. I just got a message. I didn't understand that you did. Anyway, that would have access to all of their digital information, their names, dates of birth, addresses, driver's license, social security number, all of that information. That information could just be mined and sold, and all kinds of destruction could occur. That's just one little tip of the iceberg I wanted to add to what everybody else has said, but there's no way to protect client confidentiality when non-lawyers own law firms. And this is not a baby step. A for-profit entity delivering legal services with non-lawyers owning it is not a baby step, and I urge you to put the brakes on it. Thank you for letting me hear you. Let me speak today.
Thank you. Mr. Thies, are you on? You. Keep going.
Oops. There we go. Thank you, Madam Chair. Can you hear me?
Yes.
Yes.
Okay, first of all, my name is John Thies, and I'm past president of the Illinois State Bar Association, also the National Caucus of State Bar Associations, and Land of Lincoln Legal Aid, a large geographic legal aid organization in the southern 2/3 of Illinois. I have been a general practitioner for 35 years. I currently serve on the executive committee of the ABA Solo Small Firm and General Practice Division, and I'm vice chair of the ABA Center for Innovation, and I serve on the ABA House of Delegates. In fact, I served for a period of time overlapping with Chair Myers and Judge Livingston. I'm here to make 2 points, and I'm trying to not duplicate what others have said. First, I want to discuss the recent history of these issues at the American Bar Association. Second, I want to express the concern that the substantial efforts that you would undertake in implementing these proposals would not lead to significant improvement in access to justice, and it may actually make it worse. I'll start by addressing footnote 55 in your report, which discusses ABA resolutions. I was the floor leader of ABA Resolution 402, and there is no conflict between that resolution and Resolution 115. 115 encouraged jurisdictions to consider regulatory innovations that have the potential to improve the accessibility, affordability, and quality of civil legal services. Importantly, it also said that nothing in this resolution should be construed as altering any of the ABA model rules of professional conduct, including 5.4. 402, which was passed in August of 2022, passed overwhelmingly, and it reaffirmed longstanding ABA policy, and that policy is clear. The sharing of legal fees with non-lawyers and the ownership or control of the practice of law by non-lawyers are inconsistent with the core values of the legal profession. The law governing lawyers that prohibits lawyers from sharing legal fees with non-lawyers and from directly or indirectly transferring to non-lawyers ownership or control over entities practicing law should not be reversed, should not be revised, I should say. Resolution 402 also made it clear that any reforms should not involve changes in model rules of professional responsibility 5.4. 5.4, as you all know, is about client protection and ensuring the independence of our profession. Tinkering with it, as has been said, threatens these key aspects of our justice system. And that leads to my second point. Wouldn't it be ironic if in an effort to address a serious problem we have with access to justice, we actually make the situation worse? And this is precisely what would happen if the rationale behind 5.4 or your 5.04 is not appreciated. 5.4 is about the core values of our profession and the core.
Mr. Thies, sorry, sir.
Time is up, sorry.
Thank you.
Thank you very much for your comments. And now we'll go to Judge Ronmel.
Right now, I think.
It's right now.
Jennifer Reinhold.
You can't hear her.
Jen,
No, she can't
Jeff,
hear us.
can you hear us?
Maybe type it in the chat.
No, she can't hear. She doesn't know. No.
Judge, can you hear us?
Yes, I can hear you now. Can you hear me?
Yes.
Thank you.
Thank you.
Great, thank you. Well, good afternoon, members of the commission, members of the Texas Supreme Court, and guests. My name is Jennifer Reimel, and I've had the privilege of serving as a civil county court at law judge in Fort Worth, Texas for the last 20 years, and I'm speaking on my own behalf. I'm a former chair of the judicial section of the State Bar of Texas, and I'm one of the solo small firm and general practice division delegates to the American Bar Association. In that capacity, I am part of a coalition of bar leaders, and a couple that you just heard from a moment ago, John Thies and Steve Younger. And we have been advocating on a national level against some of these similar proposals that the working group has been discussing today. Most recently, our coalition was the driving force in the American Bar Association for adopting Resolution 402 that did reaffirm the association's stance against non-lawyer ownership. As I look at this room, I see so many colleagues and friends that I have so much respect for, and especially Justice Busby. I have a tremendous amount of respect for him because we've worked together in Bar Association committees for the last 20 years. But I do have some concerns about a vote on these issues today. While I understand that all of you in that room have been living with these issues for at least the last 10 months, the rest of us in the Texas Bar Association have only been living with these issues since we received the final report about 9 days ago. Also, I have some problems about inclusion. As I'm looking on my other computer here on the appendices about who all has been included other than working group members, it looks like there was only a combined total of 49 people that participated then in either a focus group or answered surveys, and another 51 individuals that I do commend that gave individual internet comments. When you're thinking about changing and the monumental changes that would happen if we were to enact either of these proposals and the 108,000 lawyers, It is a very, very minuscule amount of people that have had an opportunity to be included. I would urge you not to vote today to at least put this report forth in the Texas Bar Journal and let other local bars also put this forth so we could have more inclusion and more time in this process. I would also respectfully, in my short time, ask for you to look at an Arizona website. It's called www.denovolawaz.com. DENOVOLAWAZ, all one word.com. This is a paraprofessional law firm website based on the Arizona Supreme Court's inaction of similar proposals. I don't have time to really discuss this website very much, but this goes to the heart, I think, of the concerns on these paraprofessional issues. Their tagline in the first, it says, your affordable alternative to offering the same quality service and experience as a family law attorney. I invite everyone, because I saw a lot of computers there and phones, to peruse this website. And if what you see, especially when I heard about less regulations in paraprofessionals practicing law than more regulations as we had in Washington, this website will scare you. And I think that you need to look at this website. And after you do that, think, is this what we want in Texas? I oppose both of these proposals. I think there was a lot of talk about non-lawyer ownership, so I am not going to be discussing that. But I say at the very least, give more time, give more.
Thanks, Judge. Your time's up. Thank you.
And I believe that Tom Riding is on the phone, on the Zoom next.
Thank you. I'm Tom Riney. I'm an attorney in Amarillo. I've practiced in Amarillo for 47 years. I am a fellow of the American College of Trial Lawyer and an annual contributor to their foundation, which supports legal services to the poor. I'm also a former member of the board of directors of both the Texas Young Lawyers Association and the State Bar Board of Directors. I'm also a former member of the board of trustees of the Texas Bar Foundation and have been a sustaining life fellow of that foundation for decades. I'm a former president of the Amarillo Area Bar Association, former president of the Texas Association of Defense Counsel, a member of ABOTA, and a member of the International Association of Defense Counsel. But I do not come to speak on behalf of any of those organizations today. Rather, I mention them solely to show that over my career, the profession has meant an awful lot to me, and also I have a commitment to legal services to the poor. But I'm here to ask you not to recommend and not to approve the proposed recommendations for changes to Rule 5.04. The working group has done an excellent job of coming up with attempts to try to regulate non-lawyers, but you cannot regulate yourself into being a professional. That is what makes us different from businessmen, and we've been told that since the time we were in law school. Regulations of NLO will not develop that long developed pattern of professionalism that causes us to be professionals. It is simply something that must be taught. We learned it from our mentors. We study it when we go to seminars, and we can't simply pass rules and expect non-lawyer business people to accept and follow and understand the principles of professionalism. As a lawyer, I have reviewed the working group report, all of the exhibits, and I've listened carefully to the comments today. As a lawyer weighing the evidence, I find the evidence in support of a proposition that this would actually improve legal services to the poor to be extremely meager. Yet on the other hand, the negative aspects of it seem to be overwhelming, particularly some of the comments in the reports from the immigration lawyers, the family lawyers, and even the tax lawyers. I urge you not to make this change, to consider all of the comments that have been considered here today and help preserve our profession. And by preserving our profession, we are protecting the public, and we are also protecting the quality of legal services to the poor. I thank you for listening to me.
Thank you very much. And Allison Hennemer.
Good afternoon, everyone. I'm Allison Kennemer, and I'm coming to you from my office in Brownsville, Texas. I'm an officer and executive committee member of both the Rio Grande Valley chapter and the Texas master chapter of ABOTA, and I'm a proud member of the Cameron County Bar Association. I'm a supporter of the ABOTA Foundation, the Texas Bar Foundation, and Texas Rio Grande Valley Legal Aid. I'm here speaking on my own behalf, but I do want the commission to know that every time I've spoken with my fellow Cameron County Bar Association members, they have shared my view against non-lawyer ownership of law firms. The task force report noted real valid concerns that you have heard echoed over and over again today at pages 24 and 25 and pages 39 and 40 of its report, but does not seem to give them the consideration that we respectfully believe they need to have. This would have, as you have heard, no real expansion of the access to justice for the poor, as we have seen what's happened in Arizona, Utah, the United Kingdom, etc. And it's not surprising, because when you have a for-profit motive not subject to the same disciplinary standards, why would you expect to get a good result? To say that a regulatory body is going to create regulations that will avoid all these evils without having any detail is not going to make that happen. There is a grave danger of substandard and even predatory or otherwise unethical practices with no real available deterrent mechanism. When you have a proposal, and one of the proposals in the report was less than 20% of the services to be provided to the poor, I don't see how anyone could reasonably think that that for-profit motive would result in deciding to dedicate the best of your legal services to that 20%. The report also discusses better alternatives utilizing existing infrastructure at pages 25 and 26, and I want to talk about two of those very quickly in my last minute. The first is law schools. The law school cohort, students and schools, have come so far in the 35 years since I graduated. They do amazing work in their clinical practice. They're uniquely suited to some of these issues, particularly the ones that are very low dollar amounts to us, but very high dollar amounts to the poor. It's like landlord-tenant law, because law students don't have the need to make a profit in any sense. They need the experience. Secondly, the legal aid societies. If you look at the Texas Rio Grande Legal Aid report for 2022, you will see that they served almost 25,000 clients. They had 32,238 new cases. They closed 21,000 of them, and they worked 2,700 hours with existing attorneys. That is where I respectfully suggest our resources should go. Thank you very much for your time.
Thank you very much. And Don Jackson.
Yes, thank you. Good afternoon. Thank you for giving me a few minutes to comment. I served as Texas ABOTA president in 2014, and I have been very active in the National ABOTA organization for many years. I am aware of and support ABOTA's 2000 resolution against the non-lawyer ownership of law firms. I am speaking today on my own behalf, not on behalf of the American Board of Trial Advocates. But I do support the comments that have been made by my friends David Chamberlain, Tim Newsom, Grace Weatherly, and Allison Kennemer, all very active in ABOTA. I do not pretend to have the knowledge or have done the work that's been done by the working group or this commission. I acknowledge that the severe justice gap that the commission is trying to address is real and is important. And I acknowledge that answering this challenge may require our profession to try innovative solutions that may make us uncomfortable. But I think all will also acknowledge that we must do this carefully and approach this with caution. I want to focus my comments on one specific point in the working group report, and that is on page 39, where the report states, in Australia and in England and Wales, where non-attorney ownership is permitted, the justice gap has not closed. However, in those jurisdictions, the ABSs are primarily profit-based. This also may be true of the ABSs operating in Arizona and Utah, as many are owned by private equity firms, litigation finance companies, hedge funds, and alternative legal service providers. And this comment appears to be well footnoted, and in fact is footnoted to the article of Steve Young, who we just heard from. it's, Judge Massengale mentioned this, and clearly the working group has made many suggestions to encourage the focus on the access of justice by non-lawyer owned law firms. But we don't have an example or a track record, as far as I can tell, that tells us that this will work. My comment is that these sorts of innovations are unlikely to stand still. They tend to continue in one direction. And I would suggest that in this case, that is probably the direction of increased corporate practice of law and corporate control of law practice. As a profession, I suggest that we must be vigilant in preserving the high ideals and legal ethics and independence. I am concerned that there is a real danger that these ideals we care so much about will be overrun by larger and richer interests. I suggest let's keep an eye on Arizona and the other places where these programs are being tried, and let's not rush into it.
Thank you very much.
Thank you.
And now Jessica Bednar.
Yes, thank you. Good afternoon, and thank you for the opportunity to speak today. My name is Jessica Bednars, and I'm the Director of Legal Services in the profession at ILES, which is the Institute for the Advancement of the American Legal System, which is a national independent research center at the University of Denver, dedicated to continuous improvement of the civil justice system. Since 2019, ILES has had an Unlocking Legal Regulation initiative through which we have worked with leaders from states across the country to rethink how we are regulating and delivering legal services so that everyone can access the legal help they need. I'll be keeping my comments very high level and brief, and I would direct folks to our written comments for further detail on each point. I have 3 main points I'd like to share on behalf of ILES today. The first one is with respect to closing the justice gap and how it will require an ecosystem of providers. The access to justice gap is massive. We've actually heard quite a few definitions of access to justice today, and I'm not sure we're all having the exact same conversation. It's well documented that the access to justice gap extends well beyond the income eligibility line for free legal aid and into the middle class. This means that serving people in the middle class is increasing access to justice and closing the justice gap. To say otherwise is to ignore the data. Because of the size of the access to justice gap, the reality is that we need an ecosystem of providers, models, and solutions in order to fully close it, including all of the recommendations that are in the report. The second point I'd like to make is just that launching a new program requires a substantial amount of resources. So we recommend that Texas prioritizes obtaining enough funding to launch the program, evaluate the program, and sustain each program individually and collectively. And then the third point I want to make is that we support all 3 models that are proposed in the working group's report. But in order for each of them to be successful, they need to be matched with a certain framework. And so just a few comments on each proposal very quickly. The community justice worker proposal, we believe this program is a great fit for low-income Texans. And there are many models already in play in Alaska, Utah, Arizona, Delaware, and Hawaii that Texas can turn to for additional guidance. And we're going to hear more probably about one here in just a second. The second one is with respect to the licensed paraprofessional program. This is an area in which ILES has devoted considerable time and energy to the advancement of these types of programs across the country, and we fully support them. But in order for them to be successful, the scope of work really needs to be broader than what is contemplated in the report, and they need to be able to serve people who are above 200% of the federal poverty guidelines in addition to people under that threshold in order to build sustainable practices. And then finally, just 2 quick notes regarding the non-lawyer ownership proposal, or what we call alternative business structures. Again, we fully support alternative business structures, but just a few notes that.
Thank you very much, but 3 minutes is up and we're trying to give everybody a chance to speak. So thank you very much for those comments and for your submission of written materials. And now we'll go to Mark Unver.
Thank you, and thank you to the members of the commission and the Supreme Court. My name is Mark Unger. I'm from San Antonio, Texas. Particular thanks to Justice Hecht, who I'm coming from a position of sort of legal technology use, background speaking. And Justice Hecht kind of gave me, I think probably my first start back in 98 when he authorized me to file the first electronic brief in the state of Texas. In 2003, I was privileged and blessed to file the first electronic filing in the prior iteration of e-filing. I think this is important because I think there's a technology aspect to it. I've been involved with the computer technology section for about 21 years, the JCIT for about a long time, since I think 2015. And I speak only for myself, however. I do think that there's some examples that were given that when combined create some problems that need to be addressed at some point. And thus the combination of both NLOs and paraprofessionals would be very dangerous to have, because I think the example given by the proponent of NLO was Raza company that in the article cited in a prior email shows that this is an AI-enabled software when we have proposed rules that say AI should not be used by paraprofessionals. And what was not said, however, but what was in the proposed rules, that the AI, unless it's checked by a lawyer, unless it's reviewed by a lawyer or the paraprofessional. So we've created almost an absurd result where the paraprofessional, unsupervised, without checks and balances, could be using and likely would be using some sort of technology-assisted app, including AI, and then have certified that they've checked it themselves and they do not have the same standards. And so I think there's problems when you combine all three of those. I don't have the solution in my head quite yet, but I do appreciate the opportunity to be heard. And thank you to everyone for your hard work on this commission.
Thank you. Gayla Corley. Gayla Corley.
She's on mute. I think she froze.
How about Nicole Nelson? Ms. Nelson?
Good afternoon and greetings from Alaska. I am Nicole Nelson and I'm the Chief Executive Officer of Frontline Justice, which is a newly founded organization that is committed to advancing non-lawyer justice workers as a critical evidence-based scalable solution to addressing this nation's justice gap. Prior to coming to this position, I spent 25 years in the field at Alaska Legal Services, a legal aid organization that serves all of Alaska. And I'm very pleased to see the recommendations of this working group with respect to advancing community justice workers. And I want to say my comments are specifically related to the community justice worker proposal. And we have submitted written comments that are available to be more specific. But really, we would like to say that the model that is proposed here, that is put forward, is we're strongly supportive of that model as a first step solution and really a proposal to move forward in a thoughtful and smart way by limiting those cases to the justice court areas. The evidence is clear that non-lawyer justice workers can provide effective and safe services to folks who need them. And the scale of the access to justice crisis in our country and in Texas really is enormous. And, taking some first initial steps to move beyond lawyer solutions to scale to be able to address the unmet needs of people who need them is really this is really essential. And the working group is to be commended for making this recommendation. I will also say that from my perspective as a 25-year practitioner in a legal aid office in a remote area, I believe this to be the gold standard for providing services to those who need it. Over the 25 years I spent as working in the field in Alaska in Alaska, I struggled to find ways to serve clients who came through our door, and we were unable to do that. This is the community justice worker model was the first thing that I have seen over that 25-year history that has the potential to address unmet needs. And so Alaska's program has grown to 325 community justice workers. They have 100% success rate in the areas that they are taking on. And they are in places where our Alaska Legal Services attorneys are not. They've expanded from the 12 offices where Alaska Legal Services has physical offices into 38 different communities. Additionally, the justice workers are closer to the communities in which they serve. So about 44% of the community justice workers in Alaska are Indigenous, as opposed to only 12% of the legal aid staff. So I'm a strong supporter of this model. Thank you.
I'm sorry. Thank you very much. We're moving to John Shaw. Thank you.
Good afternoon, everyone. My name is John Shaw, and I am a former legal aid lawyer. I practiced with legal aid in Northwest Texas for the first 5 years of my practice. I have, for the last 12 years, been on the board of directors for Texas Legal Services Center, and the last 5 of those years, I have been chairman of that board. I'm here today to speak on behalf of myself. I want to make sure that it is abundantly clear I am not speaking on behalf of TLSC or its board of directors, nor am I speaking on behalf of my law firm, but I did want to take this opportunity to tell you that I am against both of these recommendations. And I had a very detailed report I was going to make, but I will tell you with regard to the non-lawyer owned entities, I think that Mr. Younger is an expert in this area. His report is something that I used. I think we need to listen to his recommendations, because my big problem with both of these is that neither one of these proposals will actually close the justice gap. And I think that's what the commission has been asked to do, is come up with proposals to do that. My biggest concern with the licensed paraprofessionals is kind of twofold. The first is the unsupervised, non-attorney, unsupervised work. The big problem that I have with that is what's going to happen when it becomes a contested case. The reality is that people who are at or below the poverty level, whether it's the 200th percentile or the 125th percentile, have the same legal problems that you and I have. Their issues are not any less complicated, and I would submit to you that their legal issues, because of their poverty, are significantly more complicated than what we experience generally in these areas of law. Once it becomes a contested case, according to the recommendation, the paraprofessional has to back out of the case. So what happens then? Who's going to take the ball across the goal line? There's not going to be a lawyer who can do it, because we've already shown that they can't afford legal counsel. At this point, though, when the paraprofessional has to give it back, now the person who is at or below the poverty level has paid money out of their pocket, which to them is going to be a significant sum of their net worth. And now they're left with a case sitting there that has never been finished. What's going to happen with it? And in my opinion, that doesn't bridge the justice gap. If anything, it's left them worse off. Another big concern that I have with condoning this licensed paraprofessional phrase is that, unfortunately, impoverished Texans are often the victims of scams and schemes. We haven't heard much talked about it today, but notarios, I'm sorry, I'm not very good at pronouncing that, are notorious for telling people in the impoverished community that they can do things for them for a minimal amount of money that they literally do not have the ability to do. Consumers of these services are not going to be able to tell who is an actual licensed paraprofessional and who is someone simply claiming to be a licensed paraprofessional to perform these legal services for low cost.
I'm sorry. Thank you so much. And Kristen Bell is up.
Hi, my name is Kristen Bell, and I am an attorney with Texas Lawyers for Children. Thank you for the opportunity to speak today. So my comments are in response to the rules of recommendations, especially as it relates to Title V of the Texas Family Code. Our position is that any proceeding brought by DFPS must explicitly be excluded from the rules changes. It is not enough to say just an uncontested case. The rules changes must explicitly exempt any proceeding brought by DFPS. That's for several reasons. First, these cases are extremely important and complicated matters as they affect the parent-child relationship. They also involve the child client for whom this decision about their lives may actually be contested, even if the state and parent agree. Child clients in these cases actually have a statutory right to counsel, often as well as constitutional rights while in the state's care, rights of protection and freedom from physical and emotional harm. Attorneys under the Texas Family Code have been given rights, duties, and training requirements to protect children, and it is unclear how non-attorneys will be held to the same legal and standards of professional responsibility. In addition, a child client may lack the capacity to consent, and both ethical, legal, and professional obligations come into play when substituting judgment. I would like to point out that it's incredibly important that any rules changes have strong safeguards in place anytime there's a question of diminished capacity in cases where consent can be used to diminish a person's right to legal counsel. There are also many tangential legal issues that may arise in these cases for which legal counsel and representation becomes necessary. For example, education issues. In these cases, if a child is being forced to move because of a placement change, federal and state law protects that child from leaving his or her school of origin, and an attorney may need to step in and protect those rights. If a parent changes their mind at the last minute, the error must be preserved. And in CW cases, the jurisdictional dismissal date may pass. Even for parents, a parent should have legal counsel for a decision as important as a relinquishment affidavit. And it is understandable how there may be differing opinions as to when a case is or becomes contested in situations as personal and emotionally involved as these cases are. There could also be instances where an imbalance of a power deprives a parent of legal counsel when needed because it looks like their case is actually uncontested, but really for the parent, they would prefer to be heard. Based on all of these reasons, we asked the working group and commission to refrain from allowing non-attorneys to fulfill the highly specialized role of an attorney in cases affecting the parent-child relationship. If at least one state has already changed its mind in allowing non-attorneys to fulfill attorney roles, according to the report, that's Washington, we ask that we do not test the waters on cases that may involve issues as important as the dissolution of a family or the protection of a child. Thank you so much for your time.
Thank you. Okay, Corley, I believe is now available.
Yes, can you hear me?
Yes.
Good afternoon. I'd like to also echo the sentiments of my colleagues who've spoken previously to commend the commission and the working groups on their efforts to put the proposals together. I speak today as TAJC president. I'm also a private practitioner with the law firm of Mahaffey Weber. I'm in San Antonio, where I've practiced for about 30 years. I also echo the sentiments of others who have spoken today that certainly the gap to justice and the limitations on access are certainly worthy of consideration by all of us. And again, applaud the commission's efforts in this regard. However, non-lawyer ownership is simply not the way to bridge access for persons in those groups. It's just too slippery a slope. The concerns, as I see them, fall into basically 8 categories. First, the preservation of professional independence. We as lawyers are bound by ethical codes, which require us to prioritize client interests, whereas non-lawyer owners who might find their way into the judicial arena might have different interests, those to their stockholders and also to the bottom line rather than those of the client. Second, conflicts of interest. Non-lawyers' business interests may well conflict with what are the client's best interests, again, putting profit over professional work product. That could lead the way to biased legal advice or flat out negligence in the handling of disputes in whatever arena within the civil justice system. Dilution of legal expertise is the third category. Non-lawyer owners simply don't have the necessary legal knowledge or ethical training. We as lawyers spend 3 years in law school. I think the average debt for students now is around $200,000. And there's a lot of time and effort that goes into obtaining that degree, which those who have not been through that process simply can't understand. The result of this could be poor management decisions regarding what might be appropriate legal practices, standards, or the proper pathway for handling a case. Number 4, quality of legal services. Again, that kind of rolls into number 3. The 5th is regulatory compliance issues. We as lawyers are heavily regulated. Non-lawyers may not have the same type of commitment or even awareness of what those requirements are that could easily pave the way into breaching whatever duties fiduciary or otherwise might be owed. Number 6, client confidentiality and privilege. We all know that attorney-client is sacrosanct, and there certainly are issues as we faced with the in-house counsel arrangement back in the 90s on what the limits on those confidentiality and privileges might entail. Number 7, erosion of the public trust. Legal profession and we as lawyers have traditionally been seen as protectors of the rule of law. If we allow non-lawyer owners into that arena, it could well erode the public trust, which from time to time, as we all know, fluctuates based on what's going on in the media and various legal disputes around the country. 8th and final is the impact on small law firms. I know some of the folks talking about the community officer or the community judicial officers rather touched on this.
Ms. Corley, that's your time. Thanks.
Thank you so much for all of that information. And for everyone's knowledge, we're going to hear from Lucy Rica and Tom Gordon. And those will be our last 2 speakers. And they are the last 2 that we have asking to speak to. So, Lucy.
Hi, everyone. My name is Lucy Rica. I'm the Executive Director of the Deborah L. Rohde Center on the Legal Profession at Stanford Law School. I'm also a member of the Legal Services Innovation Committee of the Utah Supreme Court, which is the committee that oversees the Utah Legal Regulatory Sandbox. You've heard today from many lawyers arguing in various ways that the recommendations of the working group portend disaster for the profession and the public. I submit just a few short observations in response. Our profession, as hard as we work, is simply not serving the vast majority of people with legal needs. The number of lawyers has increased 4-fold since the 1970s, and the justice gap and the number of those appearing in state courts without any representation at all has increased dramatically over that time. In spite of this, lawyer after lawyer has come here today and argued to you that change is not needed and that lawyers are the only possible providers that can offer quality legal services, and that non-lawyers, seemingly by definition, are malintentioned and seeking to harm consumers. I want to be quite clear, the considerable academic research on the quality of services provided by non-lawyers and the impact of non-lawyer ownership in Australia, England and Wales, Utah and Arizona does not support these arguments. Non-lawyer providers already offer many services in federal and state agencies, and now as licensed paraprofessionals and justice workers in multiple countries and states. The research shows that the quality of services provided and the satisfaction of consumers is high. Non-lawyer ownership has enabled law firms and legal service entities to partner with other professionals to serve consumers in one-stop shops with their end-of-life planning needs, with their financial needs, with marriage dissolution and other family needs so that they control their family legal issues themselves with the help of lawyers as needed, with low-cost expungement services, as has been noted, and with bringing their own small-dollar personal injury claims. As a report of the Rohde Center noted in 2022, entities emerging in Utah and Arizona are creating a variety of business models and services, some of which are more innovative than others. But key to note, there is no evidence that consumers are being harmed by these offerings or by the non-lawyers participating in them. There is no evidence that lawyers working with and for these entities are unable to fulfill their professional obligations, which they are required to uphold in all of these reformed regulatory frameworks. Lawyers oppose opening up the monopoly of the profession holds on the provision of legal help. This is not surprising. But I submit that in the face of the truly shocking numbers of the justice gap and the lack of evidence showing that reducing the UPL ban and 5.4 ban, this position is without support and does not reflect the best interests of the public. I also submit that if the members of the profession continue to categorically oppose reforms, that we as a profession will lose the ability to regulate the provision of legal services, either through First Amendment and antitrust challenges or through consumers choosing unregulated providers. We need bold and courageous solutions. This, I believe, is what the Texas Supreme Court sought from the Commission and what the working group has proposed. I commend the working group and fully support the breadth of the proposals offered.
Thank you very much. I need to ask, is William McMahon on
He apparently did not accept the invitation to elevate to speaker. So, sir, if you wish to speak, it would be helpful if you would accept the invitation to elevate you to speaker status. That would be very helpful to us. Thank you.
And otherwise, Tom Gordon, are you there?
Yes, I'm here. Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working to help consumers of legal services by making the legal industry more accessible and affordable. We appreciate the committee's efforts to reform regulations that prevent people from getting affordable legal help. And we urge the Commission to, in fact, expand the allowable range of services that they're considering, not just to the poorest Texans, but to all Texans. The reason for this is the size of the justice gap, the true size of the justice gap in Texas and, in fact, nationwide. Looking at the data from the committee's report, from the working group's report, if you're an individual at the 90th percentile of income, you have to work a whole day to pay for 1 hour of a lawyer's time. This is simply not access to justice in any meaningful way when only those in the top 10% of income can afford more than an hour's worth of a lawyer's time without working a whole day to pay for it. Basically, when it comes to affording legal services, we are all low income. I've also heard a lot of misconceptions about the effect that non-lawyer ownership would have on attorney services, and I find it puzzling because we as a profession do, in fact, as we can see by the passionate commitment from people in this room, hold our clients' interests in the highest regard. So it's puzzling to me that we are so dedicated to our clients' regard and our clients' interests that only lawyer ownership of a firm is sufficient to protect it, and yet at the same time, we apparently are so weak that we'd fold in an instant if outside corporate pressure told us to do something against a client's interest. Finally, I know the time goes very quickly here. I do want to point out that when looking at new regulation, we should compare what's being proposed to the current regulation system. Right now, our current model is a Texas legal industry of $30 billion in annual revenue. And what I've not heard anybody suggest while saying what we can't do is how to reform that system to get more aid to those who need it the most. Right now, Texas lawyers average 25 hours a year of pro bono, and they're required to pay $65 a year towards a combination of civil and criminal legal aid. That's simply insufficient and frankly ridiculous. If people really want to help, they should either let others do it and step away and let them do it, or perhaps the legal industry should be required, as well as they're proposing the non-lawyer industry, to lawyers should be required to provide more pro bono work or be mandated to provide a significant proportion of their revenue towards legal aid, which greatly needs it. In conclusion, we hope that the Commission will consider expanding the available legal services from innovative models and not letting this experiment fail before it starts by restricting the scope to a small number that will not bring in a sufficient number of clients to make it profitable. Thank you.
Thank you. And now is Mr. McMahon on? Yes, no, yeah, sure.
Am I live?
Yes.
Okay, thanks. My name's Colin McMahon. I really appreciate the commission taking the time to hear my thoughts. I'm the current president of the Dallas Trials Lawyers Association, but really I'm not here in that capacity today. I'm wearing a hat of a lawyer who's run a firm for 18 years. And I'm specifically here in opposition to the non-lawyer ownership of firms. And I won't repeat a lot of what my other colleagues will say. I've already said, but I'll kind of sum up my whole position with one story that actually happened earlier this week. And I turned 45 this month, so that means I had to finish up my CLE. And like 45 minutes of ethics, so I just did what a lot of us do and went on the State Bar of Texas website and clicked on the first one I saw. The first one I saw was an interview where our State Bar of Texas Executive Director Trey Apfel had the opportunity to sit down with Texas lawyer James Baker. And in the interview, Mr. Apfel asked, what is it about the legal profession that you have seen change over the years that is, let's say, most significant to you, good or bad? And I'm paraphrasing Mr. Baker's words a little bit, but his response was, I've seen the good that has come from lawyers doing financially better. I think that's a truism. I know what is a truism. On the other side of the coin, we've become a business. We are no longer a profession. I think that's regrettable because I remember back in the days when we were a profession, people respected us more than they do today. That's coming from a man who's partner in Baker Botts, one of the oldest and largest law firms in Texas. And I couldn't agree with him more. Licensed lawyers are required to follow a code of conduct that differentiate us from non-lawyers. And oftentimes I'll compare that to the code of ethics that medical doctors follow, or the Hippocratic Oath. These ethical guidelines are what keep us professional. And instead of loosening our rules of professional conduct, we should be cranking that wrench tighter. I agree that all Texans should have equal access to justice, but operate in a world where I see the many pitfalls of hedge funds or non-lawyer investors trying to turn a practice into a business. We've got to do the best we can to protect our profession. And again, I thank the commission for allowing me time to share my thoughts.
Right, thank you so much for being with us and those thoughts. And I believe that concludes the individuals that have signed up, but also it concludes the amount of time we have allotted. So we can now, our schedule calls for us to take a brief lunch break, and that would entail 30 minutes. So if we can start earlier, we will, but let's break for lunch for 30 minutes, and we'll resume the board. Please keep eating. I know you're still eating, and we want you to do that, but we also want to go ahead and get some discussion going. And I think the logical way to handle that is to have a discussion begin with Kennan's report. Talk about the subject matter. You've heard a lot of discussion about, obviously, a lot of the commentary is on the non-lawyer ownership we'll get to, but let's begin by talking about paraprofessionals. Yes.
Great. Before we launch into subject matter, I was wondering if I could ask a clarifying question to Justice Lesby or the chairs. In terms of procedurally, what happens? So today's a recommendation for the commission for the folks to the Supreme Court and that staff. What does that look like for the next future?
Well, we asked for a recommendation from the court asked for a recommendation from the commission. So that's the report that y'all have from the working group for you today for action is a potential referral from the commission to the court. And from there, the court will study it. I don't want to speak for the court as far as whether it would be referred further to other committees, the Supreme Court Advisory Committee or otherwise. But, certainly what's approved by the commission today, whatever that may be, the court's going to take a further look at it. And as the chief mentioned in his comments, there will be additional opportunities for people to comment to us at the court before we take any action. So, he went so far as to give out his personal cell phone number, and we have an existing email address that the commission has been monitoring with the help of the state bar. To continue to be open for comment. We always take comments at the court through our rules attorney and the rules comment procedure, which is on our website, how to get in touch with her and make comments there. So our door is always open for any additional comments or thoughts that people may have. But what the commission approves today, whatever that is, will come to the court as the recommendation of the commission, and then we'll conduct further proceedings on that. So today is not the last step in the process, if that's what you were asking.
Yeah, and I just wanted to make sure the members of the public understood that as well. Thank you. We all did.
Yeah, thank you.
Very helpful comment. And so Now, there's going to be, and you've seen in the report, specific recommendations, and those are gonna be discussed and considered later. Right now, what we would like to focus on is just a discussion. You've heard all of this. Some of us that have attended all of these meetings feel very close to the subject matter, and I'm not sure that all of the commission has had that same opportunity. You have heard today the in-depth report, and you have heard commentary from the public, and we just wanted first to have an opportunity for the commissioners, after they have heard all of the report and the comments, to have an opportunity if you had questions or wanted to discuss the subject matters. First, scope of practice. That's the first section that we dealt with. So are there comments or thoughts from commissioners now, having heard the reports, and is there discussion that you would find helpful with respect to scope of practice?
I don't know if this is the right time, but we got a question about the scope of practice report that we haven't yet answered. It came through the Q&A on the Zoom. Since it was silent there for a minute, is it all right if I address that question? Okay. So the question was, what happens if in the midst of a hearing, a case becomes contested? Is there an automatic say of the hearing? And that was from Mr. Stewart Matthews, and I wanted to make sure that we respond to that. And for anyone else who's wondering, in paragraph H of the proposed new scope of practice rule, there is a provision that specifically states that resolve it is good cause for a continuance if you realize you need to get out either shortly before or during the proceeding. So in other words, if this comes to your attention, even before the proceeding starts, it's right before it or during it, that's a good cause, as opposed to the judge having to question whether it is or isn't a good cause. That would be an illegal possibility. Thank you.
This may be a question of my own, but that discussion sort of makes me want to ask or say, there's a lot of generality here, which the working group looked at, and but there's also a great deal of specifics that down the road will get looked at also. And so, for example, we haven't really spent a lot of time talking about if you are a paraprofessional, if you've received the training, if you've begun and practice with an organization, how would you be made aware of a circumstance where you've gotten yourself to a point where you couldn't go into? And those are specifics that I think, in fairness, they will get further discussed, further ironed out, and solutions offered. But these are just a good example of this isn't a proposal that's I dotted and Steve Ross, but that there won't be further consideration of the issues that have been raised and that have been heard today. So, and I think, so on scope of practice, any discussion that people feel would be helpful, having heard the report and having heard the commentary, having done your own study, do you have questions about what you heard or read in the report?
And maybe I didn't read it wrong, but is it going to be confined to legal aid services, or is it going to be any law firm or any person can help us get a license? And then how are we going to ensure that there's room for those that are in need of, so those that are So if I'm a business person and I want to make a lot of money, I figure out how to have 20 paraprofessionals or 40 or 100 working and have them out there employing and helping. Presumably, if I'm being for good and I'm charging a reasonable fee, that's good for me. Giving people immigration status, a divorce when they really want a divorce, but how do we address the issues that were addressed today that sometimes people aren't on your estate and they're not getting information. Divorce is not contested. But I think sounds good in theory, though, the reality is going to hear the talk.
You will be there. Yeah, oh, okay. So the proposals are not limited to legal aid, except for, to the extent you have a community justice worker, you can only provide services under the supervision of the legal aid attorney or an attorney at another nonprofit. So that's a category where not legal aid alone, but you see legal aid provides. Other parts of the role, there's no restriction that the paraprofessionals have to work for legal aid entities or necessarily having to be a legal aid lawyer. But I think because of the requirement that they have to be eligible for probably guidelines, the reality is that in most instances, I would say paraprofessionals are probably going to be legal aid entities, or there's going to be a check in place when they're not legal aid entities in regard to that profit motivation, in that the individual institution of services is out of the how is that check the requirement that the prospective client either have an affidavit saying this is my income. Kind of like what we see now with the affidavit when we report for fraud, right? That they're for lawyers and we probably both dealt with those and assisting the clients, but the other thing that they have is going to be informed declaration. That's not totally accepted. So they're going to be on plus either a sworn statement or an unsworn statement. You can agree with all. In terms of what happens if there's lack of compliance or disease, I would assume that we can kick over to the licensing regulation. Yes.
May I just remind everybody to please speak up as loudly as possible because we do still have participants on Zoom and we need them to be able to hear us as well. Thank you.
So would it really be the case that someone could, as Kristen said, have an organization that would go out, hire these paraprofessionals, they make a lot of money? Is that even theoretically possible with the people who are receiving service in tech?
I don't think it's, I mean, I guess theoretically it's possible, but practically it's not, there's not a profit motive here. The rules are designed, the paraprofessional rules are designed that these will be serving the poorest of the poor, and that client base will guide, how the business model works, which is, there is no business model, really.
Well, you can do that now. I mean, the Dallas Volunteer Attorney Program, Houston Volunteer Lawyers, all of those programs go out and hire lawyers and they serve people under 200% of the poverty guidelines. So you can do that right now. It's just that you can't do it with paraprofessionals. And so the proposal helps, paraprofessionals don't have to go through the same requirements as an attorney to be licensed, and they can charge less for their services. Paid as much, so those organizations can spread their money further and home for cheap. But it's the same 200% is the standard they use now, so that you would with the same verification process, concerns about that process that you would reduce.
Paraprofessionals would be going to court for this.
So you have in the proposal the parameters set out, like you can have a representation of a client in an uncontested courtroom proceeding. including the preparation of affidavit in support of temporary orders in uncontested divorce decrees, but that's only in uncontested divorce cases that don't involve suits affecting parent-child relationship and have limited property issues. And then in subpart C, you have a comparable provision saying that there could be representation of the uncontested divorce proceeding. But again, only in the types of cases that are set forth in the paragraph here in C. And those do extend to substance misuse affecting the parent-child relationship, but then the rule goes on to say that involves only standard conservatorship provisions, standard possession schedules, and guideline child support issues. So all that to say, yes, you can go in there for uncontested court proceedings and all certain types of cases.
Well, like I was sharing with you, when I was on my way in here today, running late already, a lady stopped me and said, "Are you a lawyer?" And so I stopped to talk to her. She just was beside herself. She had money, she got locked out of her house, her parents are in the age 30 with private custody of her children. And she had several different. And she was obviously very sweet lady, but didn't know what the heck was going on. So I brought her in here, we found out she was the right place, we found her what court she needed to do with it. But security guard said, "Well, let's get your car motor so it took." So, I mean, just somebody to help someone get to the right place is ideal. I just wonder, as a personal injury attorney who sees a lot of case managers and assistants, they go out and really try to practice law, and some of them are ethical and some of them are not. And so I just think we have to be mindful of the fact that this has been a gigantic and administrative regulatory body. I think it's, you can go out and give a license that presumably is for good, but I just don't know if it's for that. I think we can figure out a way to try to do it when we do it. I just think it opens the door. I'm not saying it's not needed, obviously today was a good example, someone needs help, but I personally don't know enough about what you have done the last 10 months to be through critic or proponent. I don't know what to say, except that I think we want to really think about it before we can that one, because it's very, if it's a law about things.
Yeah, and it's interesting because on the one hand, you could say this is going to open the door, and on the other hand, I think you could say, well, this is a situation where there is going to be oversight, regulation, discipline, et cetera. So we have a problem already now with lawyers and operators doing things they shouldn't do. I think there's always going to be, unfortunately, that type of misconduct, and I think. You could view it from one side, right? You could say it's gonna open the door, you could say it's gonna add some regulation that will help to reduce the risk to protect people more than they're protecting them. So
one of the things that may help too is that Arizona and I think Utah also have had maybe less than 5 complaints about the paraprofessionals that have been licensed there, and they told us that all of those have been satisfactory results. So that people reporting about the quality of the services they receive and how pleased they are is actually better than more. So,
I will say too, yes, I'm so sorry. May I conclude the thought there? On these provisions, I am not in. I do that pro bono sometimes. But that's not my wheelhouse. These were prepared by family law practitioners. And I think what we've heard from the family law bar is supported by and large. So I'm not saying that makes them golden. I'm just saying that these are provisions prepared by individuals who practice in that area. And that gives me some.
Well, my question pertains to both scope of practice and licensing in particular. How would you answer the chair of jurisprudence or the chair of finance or the chair of state affairs in the Texas Senate who would say, these are not issues that fall under rulemaking, they're legislative. Notwithstanding, beliefs about separation of powers and all that, how would you answer those chairs who would think this is something the legislature should do? Cannot be done.
That is something that has been raised. We're hearing that come up from the background.
It is in the report, as I mentioned, very briefly, even covering a lot of ground on page 7. There is a reference to statutory authorization for the Supreme Court of Texas, and specifically having the exclusive authority to issue licenses. And if you look at the statutes, it's not about issuing licenses to lawyers. It says licenses to members of the bar. So that is referenced again on page 7 of the report.
And then the legislature has also granted the Supreme Court authority to move into the JVCC, the ability to regulate additional individuals under the umbrella created by the legislature for the guardianship, for the judicial branch certification commission. You probably have that slide ready, but that is also in the report where we talked about the that authority that was granted to the Supreme Court to regulate into the JVCC.
Thank you. And on page 26 of the report, there's an interesting reference to recruiting paraprofessionals, so to speak, from near bar passers. And I wondered how that would work. And the reference is to calling upon these people who almost passed the bar but didn't to become professionals, and how that would work with NLOs. That's a reference on page 2, on page 26.
So that is one of the qualifications for a paraprofessional, so unrelated to the NLO, but it is a qualification. The executive director at the Board of Law Examiners talked about what is a near passer and how that would work. These are often individuals that are waiting to pass the bar again. You know, you can take the bar several times. And a lot of them do paralegal work or supervised lawyer work while they're waiting to pass the exam. And so being a paraprofessional would be one more way for them to bridge that gap until they're actually licensed lawyers. And she felt very strongly that they should be included, that they have the 3 years of law school, so they're educated and you know, that they have not passed the bar would not mean that they were not a competent individual who could do provide the limited legal services that we're authorizing here.
And they do qualify currently for supervised practice, and under rules that we've had for many years. They can practice under the supervision of a licensed attorney. If say they fail the bar exam the first time and then want to take it again, they can practice under supervision.
The other concern that I've heard has to do with bad relationships developing because of competition between paraprofessionals, perhaps encroaching upon the territory of lawyers, and how this could result in not only competition, so to speak, especially from paraprofessionals, they develop into NLOs, but also the problem with the areas that have what they call too many lawyers. And so we're now going to have areas where people are saying we have so many lawyers, there isn't enough work for the lawyers, and now we have these paraprofessionals who are perhaps taking business from them. Would there be an unintended consequence for the lawyers, especially the young ones, the ones who are coming straight out of the law school? And how would we resolve that perhaps unharmonious relationship?
Senator, I would love to have that problem. If we had so many people competing to serve these folks who were at 200% of the poverty level or less, we would be in a far different place than we are now. But I think that was part of the discussion, and it's welcome to chime in on the criteria, but for the paraprofessionals and the community justice workers specifically, that's why they're limited to serving people at 200% of the poverty level or below, because that they're not competing at that level. They're not competing with lawyers who are charging for their services, anywhere near a market rate, and so. Instead, they're falling within that pool that the Chief Justice was talking about, where we've got 90% of the people who are not being served currently. So there's plenty of clients to go around in that area, I think is what we would say as far as that,
Thank you.
that limit.
On page 34 of the report, you address the issue of federal funding. And I noticed that one of the witnesses brought up or articulated her assumption that this program would be paid for with state appropriations. But I see the reference to federal funding, and is that what you all foresee? That there would be a source of federal funds for these programs? That you wouldn't have for state funding? And I'm sitting on my member of the Senate Finance Committee.
So we had some discussion on this subject with relationship to JVCC, because under current law, as I understand it, the programs regulated by the JVCC are required to be self-funding. So we had some discussion with the representatives of the Office of Court Administration about that. But the way it's currently structured, I mean, there are fees that are charged, but those fees have been required to cover the cost of JVCC regulation.
The other thing that might be helpful for context, Senator, is the paragraph on page 33 leading into that discussion of federal funding.
Page 33?
Yes. There's a reference there to the anticipation that a lot of these licensed care professionals will be employed by legal aid and other nonprofit entities, and that there are funding opportunities from the federal government for those entities, right? So the federal funding is also, I think, being addressed here in relation to the legal aid and other nonprofit entities. I am not a legal aid attorney, so there may be somebody here who wants to speak to that in greater detail, but that's part of what led into that discussion of federal funding.
So, and I was not involved in this part of the report, but I'm going to assume that they're probably talking about the federally funded legal aid programs, and so it would be with their funding, which wouldn't necessarily be federal funding. It could end up being IELTS funding, would be less, it could be other funding, but it would come from their funding streams. I'm not sure that I know of a revenue stream that would just be federal funded. So that's my impression. But really saying legal aid's gonna hire folks and then they use the money they have.
Thank you. In relation to the feedback in appendix B, I believe it is appendix B, you all were so kind and so thoughtful as to include all the individual feedback. Now, I was shocked at the hostility expressed in so many of these little emails and reports. I expected more positive feedback, and I was shocked. My impression, I didn't count, and my impression was that the feedback was overwhelmingly negative. But I understand that the committee did a wonderful job of reaching out to people and getting them involved. And I saw that also in appendix B, where you have the chart figure, can't tell if it's 1 or 2, I think it's figure 1, focus group participants, where 107 people were invited, 107 organizations or people from organizations were invited, and only 23 responded. And then in figure 2, stakeholder groups, 132 were invited and only 26 completed. Could that be part of the problem? That enough people did not respond to the invitation and perhaps were negative about the issue, but did not bother to participate and express themselves and try to work it out.
We were certainly disappointed in some of that, those, participation rates on some of that. I don't know if there's something that's what was expected or not. But I will say that we did receive feedback in many other forms, other than what was reported specifically or provided as a backdrop. Just to give you an example, I went around and talked at the LBs, including the Bar Leaders Conference, and presented, 30 minutes of presentation. Here's what we're doing. Here's where we're heading, and then 30 minutes of question and answer from bar leaders, care about access to justice issues from all over across the state. And I felt like that reception was very warm and commended us for our work and what we're doing in this regard. So, we're getting feedback beyond just written feedback and beyond just the surveys that the National Center for State Courts did for us as well.
And that's just as Busby said, these people still have an opportunity to participate.
Yes, that's correct. And Senator, I'll add, in case it's helpful, that over the course of the project, we had received feedback. And at the beginning, we didn't yet have written recommendations on the page, right? And so people were responding to concepts, you know, what they thought might happen. And I think that's a good thing to do, you know, so we know the feedback at all stages. But I feel like as you get farther along, they're actually commenting on the written recommendations and proposals. Sometimes that feedback is a little bit more concrete and about what was actually proposed as opposed to what people thought might come out of the project.
Thank you.
I think one other thing you see too, Senator, is sort of like the number of lawyers that do pro bono work and donate to access to justice efforts through their bar statements. You know, what's done there is extraordinarily helpful, but it's a fairly low percentage of the profession that actually donate or does pro bono work to any significant measure. And so I think, you know, you often see, you know, number one, folks who just aren't engaged in these issues don't participate in response to requests to comment. You know, I reached out to several groups to ask their input very early in the process, including Texaboda in February. You know, we have not heard from folks who had earlier opportunities to comment, but nonetheless, you know, the door is still open and continues to be open to comment, and all of it's valuable. But I think the nature of these sorts of solicitation of feedback is that you mostly get feedback from people who are not happy.
I see. Also, I looked at the handout that was developed for the TAJC subcommittee meeting on, I believe it's August 25th or July 25th of 2003, and there's a slide there that says, "Welcome to Texas, cheap, low-quality representation." What is that slide all about? It says, "We'll attract more aliens to enter Texas, will increase the number of frivolous asylum applications, will drain our state resources, and will run counter to our state's public policies." I wonder what was the purpose of this slide in this particular handout for the subcommittee?
That was a presentation made by the immigration lawyers in opposition to our study.
Well, that explains it. It doesn't say that on the cover. I thought this was the working document from the subcommittee.
That's the part of the narrative.
And then there's another one titled State Legal Hurdles. And there's a list of 5 state legal hurdles, and I wondered if you all would address how to overcome those legal hurdles. That's another thing. I was under the misimpression that this was the committee's backup, because it doesn't say the source.
Yeah, everything appendix D is something we received feedback. Yeah.
It doesn't say. See, I read and not pay attention.
Yeah.
Yes, thank you very much, and I'm so impressed with the work. It's really an extensive body of work, very well done. And I'm impressed with the outreach that was attempted. I wish there had been more responses. Thank you for your good work.
Harriet, will you entertain a motion to approve the recommendations from Kennan's group?
Will you hold that thought a moment? I wanted to ask, Grace and Lonnie, if the response to the survey sufficed you in terms of the percentage of responses, or was that unusually low or high or what?
I was just gonna say, I would say it's about average. I think, with the survey and the focus groups were done, I think like we said, before the work recommendations developed. And once we had the feedback from those surveys and focus groups, we took that to the leadership, and the result of that, there was a lot of outreach done, like was just described in terms of the CLEs, the email feedback, to really make sure that the working group was getting good feedback, because we felt like there was feedback provided, and we again probably about an average response rate given other coverage like this, but we wanted to make sure that that there really was extensive feedback and also individual comments. So I think once we had that initial feedback, we took it to what he's doing, so they could do some more outreach and make sure that people really had other avenues to come in and provide feedback.
We also didn't initially contemplate doing a survey, it was just focus groups, and when we saw some of the response rates, we suggested that as like another means to solicit feedback, and maybe people would be more willing to do that, so. I think.
I'll speak very briefly to what's been stated about opportunity for further comment to the Supreme Court of Texas. Obviously, I have not been the rules attorney for many years now, but I can tell you from being there as the rules attorney that every single comment that came in was reviewed, and that part of my job, and I think it's the job still of the rules attorney, was to present them to the Supreme Court of Texas justices across the board. Both, physical copies and with a summary of them. And so it is not a situation just to give people comfort where these comments go and are never seen again. And I know Lisa served in that role in the past too. In my personal experience being there, I spent many hours going through the comments, providing them, summarizing them, ensuring that they were heard and they were received and considered thoroughly in my personal experience. I just wanted to share that for what it's worth for anyone who's wondering what happens from here in regard to the public comment opportunity.
And that still happens, and we, even when we do issue, we often get comments before we issue rules, while we're on it, if the Supreme Court Advisory Committee or another body like this commission sends us proposed rules, then we'll get comments before we issue anything, and then once we issue a rule, it's a proposed rule, and there's another public comment period after that, where we take comments, and we just issued a rule the other day where we made further changes in response to public comment, so it happens all the time, and I just want to emphasize that again, it's not too late today, and it won't be too late for quite some time for people to submit additional comments if they have them. We're glad to get.
Well, I think it's great that you all included everything, good, bad, and indifferent. I think that's wonderful. Very transparent.
And in the interest of just order here, I think what might make sense is for the co-chairs who have brought us here to where we are. If you all feel like you're ready to make a motion on at least one of these items, that would be helpful for me to know, but I want to know if there's any more discussion before a motion is made on that particular item of scope of practice.
Maybe Judge Payne, maybe Paul on the phone.
Well, Alistair had his comment first, so I want to make sure that's Alistair. If you still want to make a motion,
Well, if you
make a motion.
I don't want to, if you anticipate that the motion should come from one of the co-chairs, then I'm happy with them making that motion, but I'm not sensing that much discussion on this particular topic, and I know there's one of the three that we're going to have a lot of discussion about. So I was, in the interest of time, trying to move us along, frankly. But if you want Kenan or Lisa to make the motion, I defer to that. They put the work in.
Just a quick thing before we take that motion, and that is just on appendix B, whoever's creating that final report on page 95, which is that immigration section's PowerPoint. The immigration section letters there and the PowerPoint's there, but it's never referenced as an attachment. Can we just put as a note that came from the immigration section, and that wasn't a subcommittee official?
It's a great idea.
I believe Mr. Burr had a comment on
Judge.
Oh, I think we're talking about the scope of practice, because so two things I had a question about. Well, the first thing is the guidelines, not the guidelines, but the poverty parameters that we're gonna utilize, whether it's 200% or 125.
It's 200%
Is what the recommendation is. And so my question is, the difference between 35,000 and 4 people in your family, which I think is 125, and the 60,000 or so, what's the rationale, I guess, because it seems like that expands sort of the number of people that the paraprofessionals can reach, which could be a good thing, but also if we wanted to be take smaller baby steps, I guess, in limiting the scope of work that the paraprofessionals could do, then we limit the number of people if we were at the lower 125%. So I just wanted to understand kind of why the recommendation for 200% as opposed to 125.
And so again, I wasn't involved in the conversations about it, but 200% is pretty much kind of the standard for legal aid now. So the federal funder allows up to 200%. The state funding, LASA, is 200%. Veterans is 200%. So I suspect they're trying to find the standard that is typically used. I ultimately is 125%, but within a program, I think it'd be much easier if you have within a legal aid program, if they're serving clients, it'd be much easier if you had your paralegal was able to deal with everyone up to 200 instead of having to figure out bifurcate and say you can help this client, but you can't help that client.
Okay.
And so I don't know if that was the kind of the conversation, but as you know, as really the largest funder in the state, that's I think where it came from.
Okay. And so so thank you. That answers that.
There, I mean, as Ken noted in her presentation, there were people who thought that that was too low. We looked at a number of organizations like volunteer legal services providers, like that our local bars do, or that our local or statewide appellate section. Again, they will often serve up to 400% because they're not restricted by any funding mechanism as a purely, matching lawyers with clients. So I do think that there was a members of the working group. Ultimately, they recommend 200%, but I think there were members of the working group who would have seen that go up because there's obviously need between 200 and 400% as well. So,
and there were some, as I mentioned, that I said a lot, so I'll say it again in case you got lost in the mix. There were a couple of subcommittee members who advocated for no limit at all. But again, kind of going back to the referral letter that we received in October of 2022, and the specific requirement that this is for providing direct legal services to low-income Texans. I think that ultimately that is what drove the decision to have that limit, and for other people, other factors drove their vote, right? But Betty, I do want to say that everything you said is spot on and was discussed along the way as reasons why 200% makes sense.
I think we have had full discussion on that point.
Did Paul have something on the phone?
We have some raising the need lower than.
I wanted to make sure someone's answering these questions.
Paul, did you want to say something on the scope?
Just wanted to add a quick comment to the earlier discussion about LSC funding. Under the current scheme of things, LSC regulations would not permit the funding of a standalone paralegal program. A legal aid program could have a paralegal project similar to any of this within its confines, but LSC would not fund it on a standalone basis. Just wanted to make sure everybody was clear on that.
Sure.
So one of the things that I try to stay focused on is that our plans don't have unintended consequences that exacerbate a problem we're trying to fix. We talked about that a lot with remote proceedings, how it can be weaponized if it gave lawyers the opportunity to decide what's remote and what's not, because it could be weaponized against someone who didn't have a lawyer or the court. We pay a lot of attention to legal deserts, right? And I'm speaking as a rural judge, not on behalf of rural judges, but as a rural judge. One of my counties, the median household income is 26,000. So in that county, probably almost everyone's going to fall within this area. in that county, I think there are 2 lawyers that are serving the legal needs of the people there. I have concerns that if this goes into effect, it will make it an unsustainable practice. Because these lawyers are helping people like this at very low rates, by the way, whatever they can do to keep their office open, help people. I know that because I'm the only judge there. And so I see them every day, every docket. I'm doing these things behind the scenes for $150 sometimes. So I am concerned that we are going to strangle small time, very remote rural lawyers and cause a greater problem of lack of representation by lawyers, not by someone, because that could be any of these things we're talking about today. Now, that being said, I harken back to a conversation I think I had with Justice Busby, but I can't remember now which one, people over here it was. But the hat that I'm wearing today is under the mandate of the Access to Justice Commission, which is develop programs that are aimed at expanding access to justice. For me, I can see how this program properly implemented, carefully implemented by the Supreme Court would do that. So I have concerns, but I will share those at a different time. For today's purposes, I'm not saying I like the plan, but I'm saying I think that the plan as they worked so hard to produce would properly implemented enhance access to justice. So that's all I want to say about the numbers. It does swallow up almost the entire population of some of these programs.
And I will note, to ensure we have full discussion on that point, we had one subcommittee member, and I don't mind me saying his name because he gave me authorization to append his written feedback with his name on it before. That's Rob Henneke of the Texas Public Policy Foundation. That also shared that view that maybe we ought not make this about the percentage of the federal poverty guidelines. And his suggestion was that if there would be income criteria, he preferred none, but if there was going to be criteria that it should be the same as the existing standard for indigency and appointment of counsel in criminal matters. So just to ensure the record is full and complete there, I wanted to give this comments.
We actually have 2 different ways that we do that. We do it with criminal appointments, and we do it with CPS appointments under the family code, right? So ad litem for low-income Texans, where the Department of Family and Protective Services goes after their kids. So I have been aware of the difference, and y'all, when you're talking about evaluating for legal services, use 200%. Most of our courts were between 125 and 150, one or the other. So this definitely would be encompass a much wider swath of my counties, which are very poor rural work.
Such a big diverse state.
It is very different.
My concern would be, the report contains recommendations. It's not really a concern, it's an observation. And so I think in, recognition and respect for the report, that the motion should be to those recommendations. And so, that's, where we are.
Then I move we approve the recommendations from Kennan's group.
Correct.
Yes.
Clarification, recommendations to come to this group to decide what to do, or to go straight to the court?
Well, at this point, this is a decision of the commission approving the recommendations to go to the court.
Okay. Could you tell us what page they're on again?
Yes, it's appendix A, and it's page 1 through 4 of appendix A. The new proposed scope of practice rule was appointed by the practice rules of civil procedure people with justice.
And the motion is to adopt all of the recommendations.
It is.
On those.
Second that motion. We have a motion and a second, and we, can have discussion now about the motion, if anyone has any questions. Hearing none, all those in favor of the motion, say aye.
Aye.
Any opposed?
Opposed?
And I'm not seeing, I don't have no idea about that.
Did we get on the record who was present as opposed to four?
If we're abstaining, is that what you're documenting?
Yeah, that's, I'm confused as a note taker here, just to insist on note takers, when you say present, you mean you're abstaining? Okay, so Senator Zaffarini is abstaining, Christie Castle is abstaining, Kenan Wooten is abstaining, any other abstentions?
I'll abstain.
And Judge Payne is abstaining. Very good.
Thanks. Thank you. Okay, that motion has clearly passed, and we are now, moving to the licensing recommendations. And, again, any discussion that presentation, the, comments, anything about that that people wanted to discuss before we entertain a motion.
Where's the funding coming from? Because this is presumably gonna bring in a lot more people to be paraprofessionals. Where are all the extra people gonna come from? And how are they gonna pay for it? And I guess I should go over just it too.
Yeah, I'm not sure, I'm not sure I understand. You mean, we think we're gonna have an influx of paraprofessionals, current paralegals who want to be licensed paraprofessionals?
I'm just saying, presumably, if we're asking people, we're creating an avenue for people to become paraprofessionals, how are we going to regulate them? I mean, we cannot do it under the existing system, because presumably we're gonna have a whole nother group of professionals.
Well, in our discussions with the Office of Court Administration, who houses the judicial branch certification, the JDCC, and we get that wrong every time. They do believe that they can house it and that they can, and they've been regulating at least 4 other professionals over the last 5 to 7 years is what I'm gonna guess. And so they have a great experience in that regulatory area. And so we had some heart-to-heart conversations with them about whether they can take in this program, and they stand ready to do so if that's where the court chooses to house the regulatory process.
Do you have any information about how many potential paraprofessionals we're going to have by this time 3 years ago? I mean, this is hypothetically speaking.
We do not.
Right, so like, let's just say we have 10% of the population in every county across the state decide they're going to be paraprofessionals. How are we going to regulate and pay for that?
I am just gonna be so excited if we end up having, I mean, this is all about getting more boots on the ground to serve low income Texans. And if we had an influx of boots on the ground, to use that phrase I love so much, I think we would figure out a way to make sure that we can regulate them through the existing regulatory structure. And I think that would be, why that means that there are legal aid providers who have the funding to hire those people that they, that would just be such a boondoggle to this program if we do have that influx. But that would be great. Sorry. That is about it. Sorry. Thank you for the correction.
Okay, I don't sense a lot of, yes, Judge.
So as I understand it from what you're saying about it, is that they're gonna have to set the licensing fee at a certain amount in order to sustain the employees at the commission to regulate, discipline, all of those things.
Cross between employees and volunteers in that process, just so you know. So
Okay.
Each regulatory subject matter has also an advisory board that is mostly volunteers, so it's a combination of regulatory process.
Okay, thank you. I just want to make sure I understood when you said self-funding, what that meant. And then the next question I have is, I've heard talk about these professionals, once licensed, being within legal aid organizations or other nonprofit organizations. But I imagine once they become licensed, they can be freestanding. Okay, and in that vein, how is the price structure, fees, all of that? Is that part regulated? Or am I gonna be able to be a licensed paraprofessional, put my, sign out and charge whatever? Okay.
Well, that paraprofessional, licensed paraprofessional who hangs up for shingle, can only serve clients who are under 200% of the federal poverty guideline.
Okay, but we don't regulate what they charge those clients. So
There's not a.
Okay.
I think the point is they're not gonna be able to charge them a fortune because they can't pay a fortune.
Well, you hope that they don't get a fortune. If somebody said, I can do it for $1,000 or whatever, and then come back and say, oh, I'm sorry. Oh, I'm sorry.
Who has oversight over paraprofessionals now?
Paraprofessionals do not exist in Texas, so that should be a new term, but paralegals, yes, they do exist and they are unregulated. They are supervised by licensed attorneys, but they are unregulated by any regulatory entity right now.
And I meant paralegals, but I think to put the paraprofessionals under JBCC, we would need statutory changes. Because they have authority right now over guardians and process servers and interpreters.
The statute allows the court to add to that list.
The court can add to the JBCC list, so we don't need statutory.
That's right.
They already have.
They already have that.
Right, Jeff. Did you have any?
Oh, no, I was just over speaking. That's good. I'm
And
good.
I think just one additional layer of detail is for the existing paralegals, the ones who are certified, who have board certification, there's a degree of regulation there, right? Their certification. But as it stands now, you can have a paralegal who has no experience, just walked in the door and has never worked on a case before. You can have a paralegal who's been doing it for 45 to 50 to 60 years. It's a big arc, and like Lisa said, they're not currently regulated. Instead, it's on the attorneys to supervise them. It's the attorneys who get disciplined if they don't supervise in accordance with their ethical obligations as set forth in the Texas Disciplinary Rules of Professional Conduct.
Thank you.
So to clarify, paralegals have no regulation, they're supervised by attorneys. Paraprofessionals would have neither regulation nor be supervised by anybody.
They would have a lot of regulation.
A lot of regulation, and they would be supervised in certain tasks as set forth in that proposal. Not in all of it. There would be some things that would be without supervision and attorney, but always with the license required regulation.
Would the paraprofessional be able to hang their own shingle, or would they always have to be tied into, but separate from the in-mouth code?
You could theoretically hang your own shingle, but I'm not sure that that's where this is going to drive itself towards. I think this is going to drive itself towards providers and nonprofits, again, simply because of the population. The client population is going to be those who are under 200% of the poverty guidelines. And so I would love for a paraprofessional to hang out shingle and do legal aid work, or, that would be fantastic. I would have no problem with that. And the proposal, as we're recommending it to the commission, would allow for that, but they are going to be served, the sort of carrot is that they have to be serving low income Texans as that.
in some of the other states too, Judge, the paraprofessionals, there are some solo or small firm lawyers that will hire a paraprofessional who's licensed, because then they can serve more, that firm can serve more people at a lower price point. And so some small firms or solos have found it advantageous to add a paraprofessional to the firm. And so that could be another.
Go ahead.
The hope is that, legal aid entities who, have to turn away a lot of people now could hire, these paraprofessionals and serve more people by virtue of hiring them. It's interesting, the conversation too, that we're having now about the possibility of, hanging the shingle and maybe taking advantage of the system. To just add a counterpoint that was talked about quite a bit during the course of the study, some people were concerned that there would be no incentive to do this because you have to pay for a license and then you're restricted to serving individuals who are out of below 200% federal poverty guidelines. So it's interesting, a lot of different perspectives, but I wanted to add that one for what it's worth.
And there have been some suggestions that there may be philanthropists that would be able to set up an organization or give money to this effort if it really was moving the needle. Because the needle needs to be moved, so it would be maybe a sympathetic, case.
And we've seen that with lawyers on evictions to Dallas. So you can imagine that could happen with paraprofessionals as well. But I think the end point, in addition, if you've got a legal aid organization who can hire 2 paraprofessionals or 1 lawyer with the same money, they can serve more people if they have 2 paraprofessionals. Just the number of hours.
Yeah, it reminded me of like I guess that's in medical offices where there's a doctor and then I always get the
practitioner.
Yeah, do some things by themselves that have to be supervised by a doctor. So that's kind of where I was going with that.
In fact, that's the inspiration for a lot of this is the medical field and the nurse practitioners and the physician assistants that they license to have a limited scope.
And to take that analogy just one step further with the nurses, you have advanced practice nursing, and under that umbrella, there's several different categories, including my husband, a clinical nurse specialist, nurse practitioner. And so here when we have this concept of the CGW, and then separate and apart from that, the licensed paraprofessional, you can see how this might develop in a way, again, comparable to the medical profession with various types of paraprofessionals.
Don't forget the ophthalmologist versus the optometrist and the dental hygienist. We deal with it.
They were on the license, the recommendations that
I would agree with recommendations on page, what is it? 5 through 8 of appendix C to the report and recommendation. Appendix A.
Second.
All right, there's a motion and a second. Is there any discussion further on the motion of the recommendations specifically? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion.
Abstention.
Oh, any abstentions? Yes, please.
Senator Zachary, Crystal Castle, Ken Wooten, Judge Payne, and Judge Payne. Okay, great, thank you.
All right, the motion passes with those abstentions. Okay, now, obviously, a lot of discussion, most of the discussion on the issue of non-lawyer ownership. So, do you want to open the discussion on that, Terry?
I have 2 questions. Number one of the speakers said, Judge Massengale, I want to see whether this is true or not, that a vote of the subgroup was 6-3 against the recommendation. Is that accurate?
I think that that is not an accurate characterization of our process overall. I disagree with Bates's characterization. We have a description of the survey that was conducted to elicit feedback and the opinions of the working group, conclusion of our meeting, after our meeting. So there were a couple of different votes that were taken at the end of the meeting. Interspersed with those votes was discussion about taking the survey. We were discussing a number of concepts intermixed with adopting the entire recommendation on LOs. And we were talking about where to draw the line in terms of should it be 100% service to low income Texans, should it be discretion with JDCC. No vote that was proposed at the end of the meeting passed. But as I say, and if anybody questions it, I'm confident if you watch the last 30 minutes of our working group meeting, you'll have no concern about our fairness in process and our clearness in discussing what was going on. But the meeting concluded with a consensus that we would elicit the opinions of the working group by survey, which we did. This is all described in detail in Appendix D, including the full results of the survey. 75% of the working group members surveyed approved the proposals, and so.
And 25% were opposed?
I guess that's right. I'd have to.
I'm not trying to pin you down on, but I want to get a feel for that. The other question I have is, we heard from Steve Younger, and do we have any data from Arizona, Utah, or DC where non-firm ownership has been implemented in some form or fashion? Do we have any data from those jurisdictions as to whether or not the implementation of that rule has narrowed the justice gap?
First thing I want to say in response to that is none of those programs are specifically directed towards narrowing the justice gap. So if you look at the types of firms that have developed, there's many of them that are not, related in any way to providing the kinds of services that would, they're just not the kind of services that low-income people would need. There is certainly empirical evidence, and we've cited it in the report. We have a representative from Isles, one of our public commenters, talk about. There is plenty of empirical evidence that there are firms that are taking advantage of the opportunity to provide services that are needed by low-income people. I'm not aware of something that measures it in terms of lowering the justice gap. I would say if they're serving people who couldn't get served before, then that decreases the justice gap. But I don't know how you quantify the degree to which you decrease the justice.
Well, the reason I asked that was maybe I misheard Professor Younger, but it was my understanding of what he's saying in his study that he has found no evidence that non-farm ownership, non-lawyer ownership, I don't know how you want to phrase it, reduces the justice gap, increases the number of people who can't afford to need legal services or anything along those lines. If that is true, I guess what I'm asking is, in y'all's in-depth work on this, which believe me, I appreciate it, you found any data to refute what I understand Professor Younger is telling us from his study of the issue?
I think he's characterizing it in a way that is consonant with his general opposition to NLOs as a policy matter. I don't think there's any way you can say there's no evidence that it's helped anybody. I would just point to ROTSA and say, that's an amazing example of a program that has been facilitated and enabled by the reform in Utah. If there is one person whose life was changed because they were able to get an expungement of criminal record and were able to move on to improve their life, because that service is there and that service is absolutely there in a model for the rest of the country, then that is making an impact. It's making the kind of impact that the Access to Justice Commission is supposed to be trying to facilitate. So I disagree with that. He may say it's not measurable or it's not meaningful, and he can have that opinion, but he can't say there's no evidence of anything that's been happening. I'd like to say one other thing before I get a lot more questions, which is that I want to be sure everybody understands what the focus of what we studied and what we recommended in the working group is. And it was a response to the court's request that we propose rule modifications for how to do this gifting. There is obviously a very, very real policy debate to be had about whether to do. And I'll answer every question I can about that. But that was not the focus of our study, and it's not the report that we read. And a lot of the feedback we've heard today is people who don't want it to be done, and people can make that position known, but it's not really responsive to what we studied and what we recommended in response to the court's letter, because the court, and as Chief Justice Heck said at the beginning of the day, they asked us to make a recommendation of how it would be done to allow them to consider whether they should do it. It's helpful to know how you do it if you're going to think about whether to do it. So I hope that that's a helpful framework.
Very helpful. And I want to just say publicly, not only to you, but to Kevin and Lisa, how much I personally appreciate the incredible amount of work that you three conducted in leading this effort and the process by which we are where we are. It's frankly the most amazing, for me, most transparent project I've ever been associated with in any of my many. Thank you very much.
Chair,
No.
whichever way you want to go.
Ladies first.
Sure enough.
Okay, I think if everyone will look at page 96 on the report, it's an email from TAJC, and it's short and sweet and it's to the point. And I think that we need to consider, well, I'm talking about yours. 96, the PDF of the report, the appendix. It's page 96 of the report. I don't know.
Page 7 of the next page.
96 of 2. So
Did you say page 7?
Page 7 of the next page. Or 96 of the old doc.
right. I really, the other two, I was indifferent on. This one I'm 100% opposed to. I think making the profession of law a business is a huge dynamic. And I think it will change the face of our profession for us. And I think guys, this is what happened. I just went to my cardiologist about a week and a half ago, and he said, well, I used to help people, and now I'm just here to make somebody else professional. So I don't know, and maybe with both of these other proposals, we can control that, but I don't think that we can. And I don't know if I can just say I'm present here. I don't think I'm going to. I'm absolutely 100% opposed to this. I know that all the people that I know are opposed to this, and I think it's something that we really need to seriously consider before we even considering it. I think we need to force and encourage people to respond, because we have to know what the long-term effects of this would be. And it will cheapen our profession and what we do to help those who can't help themselves. And I see money, profits over people, whatever it is, because non-lawyers, most of the time, are not in business to help people or to help their clients. They're in business to make a profit. And I think it is absolutely 100% contrary to what we all went to law school for. And I absolutely 100% oppose it, and that's all I'm going to say. Please read Guy Choate, page 96 of 250. Less than a paragraph.
So
Now I'm gonna go to Alice to see his name, and then we'll go.
So,
What happened next? Next.
in response to Justice Massengale's point about the charge to his group was to come up with how you would do it if you were sort of, if it was predetermined that you were going to do it. I think that's a fair read of Justice Busby's letter. However, I think it's incumbent upon this commission in voting on the recommendation to determine whether this is a good idea or not. And as Justice Massengale, he and I have had several conversations about this topic over the course of the last 10 or 11 months. And I've always said, I don't understand how opening up law firm ownership to non-lawyers improves access to justice. How does that improve access to justice? And I've looked through the materials. I've looked for empirical evidence that places that have tried this have seen an improvement in the justice gap. I haven't found it. It is probably true. You gave I think Justice Massengale gave an example where one of these non-lawyer owned businesses was able to provide services at a lower cost. It is probably true that there'll be some incremental service provided to lower income Texans. But I submit that the harm and potential harm that comes from this greatly outweighs what might be an incidental benefit. And I'm also mindful, some people say, well, it's a trial period. We're just giving it a try. Once you've opened Pandora's box, you ain't getting that stuff back in there. It's not. And so I think the potential harm greatly outweighs what I see as a potentially very small benefit. I think that these, the majority of these non-lawyer owned businesses they're going to be there to make a profit. They may be able to do it at a cheaper rate than some of our hourly rates in this room, but they're there to make a profit, and so they're not designed to provide services to low income Texas. That's not where the money is. And almost every business I know of goes where the money is. And so I am against the recommendation, with all due respect to my good friend Justice Massengale. I just don't think it's not going to help. It's not going to make a meaningful difference in access to justice, and it has the potential to cause great harm in our profession.
Okay,
If I could just have the counter to that, as somebody who's studying this for a year, is that we won't know that until we try it. And, this is why the recommendation from the working group is to create a pilot project. Because it's easy for you to say, I don't see how it's gonna help. And I can't really say, well, I disagree. I mean, I can say I disagree, but neither of us can be right because we haven't tried it. And that's what a pilot project is let's try it. Let's see what innovative ideas are out there. If it's expunction, it's one of them that we know about, that we're all like, that was a great program, but we don't know what other ones are gonna come out there. And I think that's why the court wants to know, as Justice said today, not whether this is a good idea or a bad idea, but to quote him, he said, how it would work best if we try it. And so that's why, in addition, and I don't have an opinion on whether we should, as a commission, take a position on that or not. I'll leave that up to our leaders. But I do know that the court asked us to figure out how it would work. And I think we provided a very narrow proposal of how it would work in a pilot project so that we can test whether or not it will help us in Texas.
What page is the recommendation on? I just see it page, are we voting on page 9 and that possible change to the rule? Are we voting on 7 recommendations?
You're always on point. That's Nightingale. I think we're to the point where we need to zero in on exactly where the recommendations are and exactly which ones we putting forward. And that one, be the senator's question and get some clarity, and then we can continue to have some discussion.
May I join in the discussion, Jim? I've had my hand up for a while, but respond to something that was said.
If you put it down, I might call on you. I'm trying to get something clarified for the senator. Would that be okay?
Of course.
Okay, so I outlined this at the end of my presentation, and I wrote what I would propose, try to avoid some of the problems we had at the end of our November 2 meeting, that were too many moving pieces in one vote. I would suggest doing first vote about establishing a pilot, and this is all framed by responding to the court's request for proposed rule modification. First, that we recommend.
She just asked where it was.
I'm sorry.
What page? Because I was looking at page 9 under the other recommendations.
And one dollar.
What I'm looking at is Appendix A, this rule, it's page 11 of Appendix A, is what I proposed as language, or what the working group proposed as language Supreme Court order. And then for the substance of the proposal of what the JDCC, we would recommend to the JDCC. The summary of the working group's proposal is on page 51 of the report.
Okay. Judge Ferguson.
I think everyone knows there have been probably hundreds of hours of the smartest people on access to justice trying to understand the letter mandate we got and what's in it and what's excluded from it. I want to suggest that the letter mandate is not the only thing that constrains what we do in this body. We are not a society. We are not a club. We are the Access to Justice Commission that was created by the Supreme Court in 2001 with an enabling order. That order tells us what we can and cannot do. And it constrains us to develop and implement policy initiatives designed to expand access to and enhance the quality of justice. Based on what's in the report and the public comment that we've heard, I agree with Alice. I feel like what we have heard and what I consider to be a revolutionary change by changing who's allowed to own the legal profession. We don't have evidence to show us that that plan is designed to expand access to justice. And we've heard it from a bunch of different people that that's not why anyone else has done it. And they can't prove that that's what it does. So my perspective on the mandate issue is that our mandate as a commission compels me to vote no, because I haven't heard any evidence to indicate that that's what this is designed and developed to do. Now, the issue of whether or not we should try it as a pilot program. We're not talking about putting kiosks. We're not talking about using a form or putting automatic texting. We're talking about bringing corporations in and giving them control, potentially, over the disposition of legal service. We see it in medical. We fight it every day with our insurance companies. I'm fighting them now. We've seen it in other industries. This is not a small change, and Texas is a leader, but being a leader doesn't mean you're reckless. It means we have a higher obligation because other states look to us. And I'm very concerned about Texas rushing forward in the face of what I have seen as almost universal opposition from our profession and its associations and leaderships. And trying something that may be a foot in the door that we can't get out. This is big money, big power potential. And we've heard from other states, that's who's coming in, is the big money and the big power. They have the ability to flood our market with advertising, and they can say whatever they want and we can't push back. Getting them out the door, that concerns me. I think there are a lot of ways that this group consistently addresses and improves access to justice. I don't think this is it. So I'm gonna vote no. Thank you.
No, sure.
If you let me, say something, just, I'm asking Gail, I keep hearing words like it, and this, and that, and all of these things that we are being asked to consider. And that's what is identified that is terrible and people are talking against. But I don't, believe that the it or the this or, what really is being suggested is identified or described or, proposed. Because what the courts ask us to do is to consider various processes that might result in an entity that could be formed and actually moves the needle for us, which no state is doing across the nation. We know that. And Texas is always ahead of the game. We've been ahead of the game in access to justice. So I would suggest that we spend some time, if you don't mind, on identifying the it and the this, because it's not turning over corporations to non-lawyers. There's a lot of what sounds to me to be sort of conclusory thinking that is saying the court is going to do things that it's not clear at all that they're going to do. And that to me is our blocking the potential for access to justice being further in a state that's best known for doing it. So I would want us to discuss whether allowing exploration of what the court asked us to outline and what the group identified isn't that what we're all about? Trying to be innovative. And I've fought this issue in the past. This isn't the first time. And when I say this issue, I'll identify it. The non-lawyer ownership issue. This isn't the first time it's being suggested, but now it's being suggested that we consider it in a framework that has different protections, different parameters, different guardrails. And I do think we have an obligation as the Access to Justice Commission not to slam a door because we see some potential that may not anywhere come close to what the court might do. So as chair, I do feel an obligation to speak when I hear courts ask us to do this, and we're not saying we will do that. We're saying we don't think your idea is worth considering, and that troubles me when we have the court we have. So
purposes of note taking, can I just ask a clarification about the three things? I heard you say break things up into three buckets, sort of, and I didn't get
Three motions, it's three motions.
I got the pilot project, the recommendations, and
The second would be the pilot program would be administered at the direction of the court and overseen by the JDCC with the advisory board establishing policies. The third piece is how to measure whether the entities are adequately serving low-income Texans. Should it be based on a percentage basis? My personal proposal and preference is that the JDCC be given discretion on a case-by-case basis. That's the motion I would make.
thank you.
I think it would be helpful to me, at least, I don't want to speak for any of my colleagues, but the bullets on page 51, I think, address several of the comments that were made in the public discussion today. And I think it'd be helpful for the court to know if those don't in fact address the concerns that were raised. If not, why not?
Very helpful, but that's not the motion. What I wanted to see was a written motion, a written recommendation that we would vote on. So what's on my page 11 is not what the judge just said. What I have on page 9 is simply a proposed change to the rule, but these points on page 51 certainly are clarifying. Good discussion.
I am circulating to all commissioners by email.
Why don't you put it up there?
Sure.
And then maybe we want to look at our rock records. Okay, while we're trying to get that, anybody else have any thoughts? That this is helpful dialogue, and I think we ought to have,
Thank you.
He said he did.
That's, did you want to say something else that mentioned? Okay,
I'm sending the email.
thank you.
So a couple of things. As I explained, the working group did deliberately focus its attention on what I would call the procedural aspects of this. That was its own year-long, very time-consuming and work-intensive project, and that is the report and the recommendation we brought to the commission. I would think if the commission were to contemplate taking a position on policy of NLOs, the commission should get a report and a recommendation on that. That's not the work that we did at the working group. Most of the comments that we heard today were not responsive to the work of the working group. I thought that Judge Ferguson drew a good distinction earlier today when he talked about his role on the commission and his perspective as a rule judge and how that might lead him to approach today's meeting in one way and how he might address the court or others on the same topic in the future. I think that's a useful paradigm here as well. The court has asked us to recommend rule recommendations, modifications, and I think that people on this commission in good faith can respond to that and have a separate opinion about whether the policy is a good idea. Feel free to express it. as to whether we should today respond to the court in a way that suggests that we think that their proposal is, or what they've asked us to do is a bad idea. I just think it would be bad for the commission institutionally to do that. And I'd really like to say more about it, but in the interest of time, I just think that our mission is to promote access to justice. These proposals are being put forward in that spirit, and I think it would be quite unfortunate if the response of this commission would be held for we think that this was a bad idea and you shouldn't have sent us off on this mission.
Could we table voting on this until we see how the other two proposals that have passed, what their effect is on the access to justice?
Anybody can make a motion that they would like to make. We do need to move forward. The request from the Supreme Court was on the agenda, and the year-long study where it's been considering the request and recommendations. That's what's on the agenda, and I think that's what we have to deal with at this point. And obviously there are strong views about non-lawyer ownership. Everybody in the room that's a lawyer has probably a different level of concern about that, but they're in the lawyer life that doesn't have that. For it to be implemented in a way that would be instructive of the profession. But you have to make the jump to whatever is going to be suggested is going to be instructive of the profession before you could get from the work. So I think we need to focus on what's before the commission today, if we could. But something's up there, so what would we like to do with this?
I'm sure if you'll entertain a motion, I'll offer.
Okay.
I move adoption of the working group's recommended rule modification to establish a pilot project to provisionally establish an exception to Rule 5.04 for entities that are certified and licensed to perform a defined scope of legal services. The pilot program would include an application procedure and rule guidance to ensure that the approved entities actually provide needed services to low-income Texans, including the features described in the summary on page 51 of the working group's final report. And also including the proposed Supreme Court order that is in Appendix B, or is it A? Appendix A.
Please take the highlight off. It makes it hard to read. Thank you. So your motion is would move adoption of the working group's recommended rule modification to establish a pilot project. And the theory there is that the pilot project is a effort to see what could be done in a project that has moving forward with access to justice.
Yes.
We didn't say that.
I'm not sure I understood, but you're looking.
I'm gonna second that so we can continue discussion.
All right, we have a motion and a second.
And I'm gonna continue discussion. Do I understand in the motion that this is not a vote whether it's done, but it is a vote to accept your work group's recommendation to go forward to the Supreme Court if the Supreme Court decides it is done?
Yes, that's exactly what I'm proposing. I'm proposing to respond to the court's request for the proposed rule modification.
If just to cut through, if you say that is the same for each of the three proposals that you're getting ready to have made on one and make two more, I think that makes the vote more clear for this room and what our job is.
But I don't think that's the motion. The motion is the working group recommends a rule change to create a pilot program, not that there's a recommendation that we consider this. The recommendation is to create a pilot program, right?
The working group recommended to the commission a rule modification program that is, that could be sent to the Supreme Court as the commission's response to the letter that the court sent to the commission last year. The court asked the commission to propose a rule modification. The working group studied and developed a proposal for a rule modification. My motion is essentially for this commission to accept the working group's proposal for the rule modification and pass it on to the Supreme Court. The pilot project is part of the proposal.
That is at appendix A.
What the letter said that the court was asking the commission to make recommendations. And the pilot group is giving us proposed recommendations that we can either make to the court or not. Is that not what about it for the commission? The commission has been asked to make recommendations to the court.
The commission has been asked to study the rules and propose a rule modification.
Okay. But it's not the work group, it would be our recommendation.
Oh, really?
That's correct.
That's what it is.
That's what I'm saying, but that's not the way it sounds. Like we're passing on the work group's recommendation. We're not, we're adopting it as our recommendation.
Yeah, I was unclear about that.
Yeah. It would be our recommendation.
I'm not an attorney, so all this professionalism today, it's not exactly what I'm thinking about. I'm trying to decide what John Q. Public would think. And I'm having real concerns about John Q. Public being able really to understand the pros and cons to law firm here and other business here. And could they really distinguish between the two and pick what's appropriate for them? And that's my concern.
Thank you for that.
Great. I looked on our website for the purpose of this commission. And it sets out specific aims of the commission. You can boil it all down really into looking at ways to create a more equitable access to justice for our citizens. Now, on the one hand, I hear from Stephen Younger, who may have an agenda, granted. But I have not heard any data to rebut or suggest that this kind of program, pilot or otherwise, is going to increase equitable access. Point one. Point two, we have heard a lot of diverse opposition. And it seems to me that as a commission, we need to take that into account. And so if I'm looking at the guidelines, and the third point I would make, and I agree with the chair, that it is challenging for us as a commission to be perceived as thumbing our nose, so to speak, at the Supreme Court in the request. I am very concerned about that issue, particularly as the chair pointed out, this Supreme Court, which has been so steadfast in support of access to justice issues for so long. That is a mighty a factor in my decision. As my friend Allison would say, however, we have a huge amount of opposition. I think that probably everybody in this room would share a concern about non-firm involvement in our profession. And I come back to the lack of data. We've had foreign countries look at it. We've had Arizona, DC, and Utah have a program. But we don't have any data to suggest that it has enhanced the access to justice. So if I look at our guidelines and our mission statement on our website, I agree with the judge over here that we do have an obligation as commissioners to look at this sort of in a broader context. And with that, I'll shut up. Thank you for allowing me to speak.
Thank you for your comments. I think, are there others that would like to speak at this point who haven't spoken, or those that have that would like to say more? I think,
Period.
Sorry, Madam Chair, I don't know what the procedure is, but may I make an amendment to the motion on the floor? Is that what I do?
Yeah, you move for a friendly amendment, and then it has to be accepted.
I'm moving to amend, and again, I'm gonna say, I think we should table this until we see what the other two proposals do for access to justice. Given all the opposition from all the public members, given all the opposition from the people of this commission, and given the uncertainty, I think it would be best to table this until we have at least a year of the other two paraprofessional. We just need to see, and we need to wait and see what the paraprofessional program does for access to justice.
Like friendly amendments go back to him, and if he says no, he can make the amendment to the whole body.
But a motion to table is a separate motion.
Right, so
The table
Justice
is
Massengale would have to either accept or not accept the proposed friendly amendment.
I don't accept it. I appreciate the concerns, but I think the court gave us a deadline to provide the rule modifications, and we busted our tails this year to meet that deadline, and so I can't accept the friendly amendment.
Question on the motion on the floor.
Yes.
Yes.
Can I suggest a hand vote so that we get an accurate count as opposed to just a aye and nay?
So what would I tell the board is the response to our request?
We haven't voted yet. We haven't voted yet.
Oh, I thought that was nice to take.
No, there's
No.
That was the first amendment, which was I accepted, so now the motion, as I understand it, is Justice Massengale's motion, seconded by Roland Johnson, to have the commission approve the subcommittee's recommendation for the three things he's included in that recommendation, including the creation of a pilot project aimed at low-income Texans, not other things, but just low-income Texans, correct?
Yes.
Yeah. I don't want to misstep here, but one thing that we haven't talked about that is said in the letter and in the motion is that our efforts are directed at low-income Texans. All these other programs that people have pointed to as concerning are not that limited.
Well, but hey, in fact, the proposal doesn't limit it to low-income Texans.
But Alan, if you look at page 51.
I get that there are protections in there, but it's not limited. It's not you can only serve low-income Texans. You have to convince the body that you should get your license for the following year by showing that you did serve low-income Texans, but it's not limited to that. So I just want to be clear that it opens non-lawyer ownership up broadly with a goal or an aspiration that it will be that that they will provide work for low-income Texans.
But if I may, the one thing that I have a significant
Is
concern
it
about.
okay if we keep talking because there wasn't?
There was a call of the question,
Yeah, there was a call of the question.
so we should vote.
We haven't voted on the question, so.
You're ready to vote. Defeat the motion to call the question, which is another way of saying a motion to end debate. If that
Mhm.
motion fails, then the debate may continue,
Mhm.
as I understand it, not being a certified prosecutor.
Yes, yes.
Question, withdraw the motion to raise the question so that the discussion. Let him vote.
Well, I second the call to the question.
So there's a motion to end debate. All those in favor of ending debate? Okay, we want, do you want that recorded? Do you want?
If you're persuaded that it passed, then I think we can move to now move on the motion. Okay.
The call for names, we only have for ayes.
Are there names?
Yeah, this is for the end debate.
Right. It's the end debate.
I think everybody's.
This is the motion to
End
end
debate.
debate.
Terry wants to talk some more. So now I think, Harry, you would call for a motion on Michael's motion, Justice Massingale's motion.
Now calls for a vote on Justice Massingale's motion, and I think Allison that helped. All those in favor of the motion on the floor, say aye.
Count, if you could raise your hands on that.
Six.
All those, I'm sorry?
Is there any commissioners online?
Yes. Well,
No.
Oh, Pablo, looks like you're.
All those opposed to the motion? Eighty-six.
And any abstentions?
Any abstentions? Any other, issues? I believe that completes our, agenda for today. We do have some other, matters that we need to talk about, though, so.
Can I just for purposes of clarification again, is there to be some statement by the commission back to the court with regard to working group 3?
Is there any
I
further?
think I think if there wasn't a recommendation in the statement, there's no recommendation on NOA or NAOs. On the NAO question from the commission.
Okay. Is there any, other, matters on the, recommendations to the Supreme Court to come before the commission?
Madam Chair, there's been a request to debate the outcome of the motion. For people who were here, we did not hear it.
The, motion that was made by Justice Massingale, failed on a vote of 8. Okay, I think, my report and comments, are, next, and, I do, want to mention again that there is an LSC, Legal Services Corporation program that will be presented in January, and we hope the commission members will see if they can be present for that and come and participate and support. And this is their 50th anniversary, so they are very excited about celebrating that 50th anniversary, and also very hopeful that people will participate, attending if they're able to do so. It's on the 22nd of January in Houston. And, there are some materials that will be circulated about that. And then we do need to go into executive session. We do have a couple of matters to consider in executive session.